name's Anita Green. I'm the Committee Chair, and I declare open this public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the Criminal Code Amendment, Genocide, Crimes Against Humanity and War Crimes Bill 2024. I acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I would also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's public hearing. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House and via the web. For people participating remotely, I'm the Chair of the committee, Senator Anita Green. Joining me today in person is the Deputy Chair, Senator Paul Scarr. Senator Lydia Thorpe is joining the hearing remotely. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the committee as a contempt. It is also a contempt to give false or misleading evidence to the committee. Witnesses are reminded that in giving evidence that reflects adversely on another party, the committee is generally required to give that party reasonable access to the evidence and an opportunity to respond. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence. This is described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness speaking for the first time should state their full name and the capacity in which they appear, and witness should speak clearly into their microphones to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode, and if it assists witnesses who are online, if you're not speaking, if you could have your microphone on mute, but obviously we'll try to work through giving everyone a chance to speak. It now being 9:30, I now welcome the first panel of witnesses via video conference today. Dr. Monique Cromer and Dr. Anna Hood, who are joining us by video conference, and Professor Sarah Williams, Dr. Emma Palmer and Dr. Natalie Hodgins. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For those of you appearing from overseas, Yes, sorry. Thank you for joining us, first of all, from overseas. That's quite the effort. Please be aware that protections of parliamentary privilege only apply within Australia. So if you have any concerns that you may be threatened or disadvantaged on account of the evidence you are giving, please bring that to the committee's attention. For the Hansard record, can you each please state your full name and the capacity in which you appear today? We'll start with Dr. Cromer.
Yes, my name is Monique Cormier. And I am an academic at Monash University Faculty of Law.
Thank you. And Dr. Hood?
Good morning. My name's Anna Hood and I'm an academic at the University of Auckland.
Thank you. And Professor Williams?
I'm Sarah Williams and I'm a Professor in the Faculty of Law and Justice at UNSW Sydney.
Thank you. Dr. Palmer?
Hi, I'm Emma Palmer and I'm an academic at Griffith University in the Griffith Law School.
Thank you so much. And Dr. Hodgson?
I'm Dr. Natalie Hodgson and I'm an Assistant Professor in Law at the University of Nottingham.
Okay, thank you very much. And thank you so much for everyone for joining us today. Do any of you have a brief opening statement that you'd like to make before we go to questions? Who's going to go first?
I'm happy to go first if that's all right.
Yeah, thank you.
Okay. So thank you very much to the committee for inviting us to present our views on this bill. I'm speaking on behalf of Dr. Anna Hood and myself, and as set out in our submission, we endorse the proposed removal of the Attorney General's consent requirement. Australia has a responsibility under international law to ensure that international crimes do not go unpunished. The extremely broad power of the Attorney General to refuse consent to commence proceedings represents an unnecessary obstacle to this responsibility. The fact that the Attorney General is empowered to refuse consent without providing any reasons and with almost no avenues for challenging, appealing, reviewing, quashing or even calling into question that decision means that there is very little accountability for the exercise of this discretion. The one limited avenue for judicial review was attempted in 2018 when the case of Taylor and the Attorney General was brought to the High Court, where the majority of the justices interpreted the wording of section 268.121 as requiring the Attorney General to be the only one to initiate any prosecution for war crimes, crimes against humanity and genocide. So the High Court's interpretation of this clause restricted an already narrow pathway for the prosecution of international crimes in Australia. It's our view that private citizens should be allowed to initiate prosecutions for international crimes under this legislation. The right of individuals to institute proceedings for Commonwealth offences is preserved in the Crimes Act 1914 and in the Director of Public Prosecutions Act of 1983. And there are already systems in place to prevent the abuse of this private prosecution process, including the fact that the Commonwealth DPP has the power to take over or discontinue a privately initiated prosecution if appropriate. So in making such decisions, the Commonwealth DPP also has robust prosecutorial guidelines to follow, whereas the Attorney General does not have any such guidance at present. The one exception that we would see for the role of the Attorney General is to allow them to quash any attempts to initiate prosecutions against heads of state, heads of government or foreign ministers who may be visiting Australia. Under international law, such individuals have absolute immunity from foreign domestic jurisdictions while in office, and it would not be legally or politically appropriate for Australian criminal proceedings to be commenced against such individuals. And if Parliament does decide to retain the Attorney General's consent provisions more broadly, we recommend that that amendments be introduced to require written reasons for any decisions made in relation to prosecution for international crimes, and for those decisions to be subject to wider judicial review. Such minimal safeguards would go some way towards preventing any perceived or actual abuse of political, perceived or actual political abuse of this power. Thank you, and we look forward to your questions.
Thank you. And Professor Williams, did you have an opening statement on behalf of your
I do,
colleagues?
Thank you.
Thanks.
So thank you to both the Chair and the committee for the opportunity to appear in person before the committee today. As you note, I'm making this statement on behalf of Dr. Palmer and Dr. Hodgson and myself. We suggest, and our submission suggests, that the starting point for the committee's consideration of the bill should be Australia's oft-expressed commitment to supporting international criminal justice. Australia's legislative framework should enable it to prosecute international crimes domestically and to ensure that decisions to prosecute are principled and consistent. In seeking to remove the requirement for the consent of the Attorney General to prosecute international crimes, the proposed amendments go some way to enabling Australia to achieve this outcome. Our submissions draw an important distinction between international crimes that are committed within Australia by Australians, and perhaps also international crimes committed by Australians overseas, but also those crimes that are committed outside Australia that do not involve Australians at all, to which we would say the principle of universal jurisdiction applies. We suggest that different legal and policy considerations apply when you consider those two categories. We support removal of the requirement for Attorney General's consent for crimes committed within Australia or committed by Australians. To retain this requirement is inconsistent with Australia's international obligations. Having a political actor exercise a veto on prosecutions exposes this process to at least the perception of political interference and risks exposing Australians to prosecution before the International Criminal Court. So this change will be achieved by the proposed reforms. For universal jurisdiction crimes, so for those crimes committed outside Australia by non-Australians, we support replacement of the requirement for Attorney General's consent with a requirement for the consent of the Commonwealth Director of Public Prosecutions. This recognises that such prosecutions can be complex and require an additional level of review before proceeding. However, we believe that that level of review can be provided without the involvement of a political actor, here the Attorney General. Instead, the Director should make this assessment after applying the DPP's two-stage test. We do suggest, however, that additional guidelines should be prepared for the Commonwealth DPP to apply when making decisions in universal jurisdiction cases. We also note that the bill does not appear to remove the requirement for the Attorney General's consent for universal jurisdiction cases anyway, due to how we read the operation of Section 16 of the Commonwealth Criminal Code, which is a separate provision that also imposes Attorney General consent. So that is something that we suggest should be clarified. In the event the requirement for Attorney General's consent is maintained, we agree that the exercise of that discretion should be governed by guidance issued in advance, supported by a requirement to give reasons. That decision should also be subject to judicial review. We agree that the bill also provides the opportunity to reconsider the proper role of civil society and private prosecutions in relation to prosecution of international crimes, and we note that that has been effectively foreclosed by the High Court decision already mentioned. So in sum, we support the bill to the extent it proposes changes that will make Australia's process for prosecuting international crimes more transparent and accountable. We suggest, however, that the bill raises issues that do require further consideration, and we remain at your convenience to assist as we can. Thank you.
Thanks very much. We'll go to questions from senators, and Senator Thorpe, I'll give you the call to start off with.
Thank you very much. Can you hear me?
Yes, we can, Senator. Loud and clear.
And thank you for appearing today. It's been very difficult to get this inquiry up, and some efforts from government to dodge even the timing and how long we have to have this inquiry. One day with a very short time frame is not enough to talk about genocide here or anywhere.
Senator Thorpe, if you've got a question for the committee, it's not true, but Senator Thorpe, if you've got a question for the witnesses, go for it.
I'll hold you up, Chair. So, Professor Williams, you state that if the AG's fiat was to be retained and reasons for any decision made by the AG relating to international crimes should be recorded and given to victims and relevant parties for review of decisions to be possible. Would you support a publicly available record of such decisions and their reasons? What could this look like?
Thank you, Senator. And that is something we did consider. We discussed quite at length when we were making our submissions. I think the reason we decided that wouldn't be a public form is really to protect victims and victim anonymity, and also obviously a lot of international crimes can raise quite significant victim protection and witness protection issues. So our concern there was, A, victims may not wish their claims or any evidence or even their connection with a possible claim to be made public. And we also thought it might raise just very serious protection issues for some of those witnesses, particularly if we're talking about cases that are happening overseas and victims may be overseas. Our ability to actually protect those victims is quite limited. If they're here, it's perhaps greater, but we decided on balance that not having a public register or anything like that would be in the best interest. It's also consistent with how the Commonwealth DPP would deal with other victims of other serious crimes. They deal directly with those victims through their own procedures and don't tend to make that publicly available. What we did discuss, which could be an option, is requiring, depending on which actor is required to give consent, either the Commonwealth DPP or the Attorney General, to publish at least statistics on the applications, number of consents they're giving and not giving, and perhaps a more generalised, anonymous kind of summary of the reasons why and the situations that were raised, obviously bearing in mind the need to have discretion in that as well. And that could be a requirement to table something to Parliament, or it could be just something to have made available on their website. But it should be either through Parliament or through the websites, or both, preferably. Thank you.
Thank you. You point out that section 16.1 of the Criminal Code duplicates the requirements of section 268.121, which are targeted by my bill, and that if my bill was to pass, there will still be a requirement to be seen to get consent from the Attorney General for the prosecution of international crimes where the crimes are committed outside Australia and by those who are not Australian citizens. You further present 4 options on how to deal with this. Can you please outline these options and advise which one you believe is most aligned with giving most effect to the Rome Statute on the Genocide Convention and our international obligations?
Thank you. So I should clarify, that's our reading of section 16.1. We think it still retains the need. It obviously addresses a much broader category of crimes than the international crimes under this division. But we think if it's obviously it's retained, it's not impacted by this bill. So it would continue to operate, which would require, at least as we read it, Attorney General's consent for those crimes that don't have that connection to Australia through either being perpetrated here or involving our nationals. So we think that would still operate. So in terms of the 4 options, we suggested as option 1 would just be to leave the bill as it is, accepting that would retain the Attorney General's need for consent for crimes committed outside Australia by non-Australians. Option 2 would be to retain that provision and the provision for consent, but to provide some greater guidance around the role of the Attorney General, perhaps having a set of legislative or policy guidelines listing the factors that he or she should consider when making their decisions. Option 3 would be the need to retain some level of consent, but to place it on the personal decision of the Commonwealth DPP instead of the Attorney General. And similarly, there could be some guidance and some factors around what the Commonwealth DPP should consider. And finally is just to repeal section 268.121 and also to amend section 16.1 to just completely remove the requirement for Attorney General's consent for all of the crimes within this division. We decided to discuss that option 3 would be our preferred option. We think if you are looking at cases that happen outside Australia with no real connection to Australia through either Australian nationals or Australians being perpetrated on Australian territory, there are still some factors that do require a level of supervision or review. We've seen in other countries these types of universal jurisdiction cases can be quite problematic. They're hard to run. It's very difficult to get evidence. It relies on cooperation with other governments usually to get our investigators on the ground. We've seen how challenging some of the investigations will be coming out of, for example, the Brereton report and the Office of Special Investigator there. So in our view, there should be some level of review of those decisions to proceed. We felt it was best for it to be the Commonwealth DPP who will apply that first stage evidence test. So they would only proceed to prosecution if the evidence is there. And then secondly, they will apply the public interest test. At the moment, the way they apply that test is obviously focused on crimes within Australia. And so what we would suggest is that the criteria they're using for these types of cases that have very different constituencies, so both Australian and international audiences and stakeholders, if you like, they could have more specific requirements and factors to consider when they're looking at those cases. But we do believe that there should be some level of control on those types of cases, but we don't think it's appropriate for that to be a political control in the form of the Attorney General. We don't think it's necessary for it to be that type of control. So thank you.
You're just on mute, Senator Thorpe. Apologies, we can't hear you.
Sorry about that.
That's okay.
Thank you, Ms. Williams, for that answer. Just going to Dr. Cormier and Dr. Hood. In your submission, you pointed out that since 2018, following a High Court decision, proceedings must not just receive the AG's consent, but be also initiated by the AG, meaning that under current law, private citizens can no longer file applications for the prosecution of international crimes. Is this in line with the intention of the Genocide Convention, one? And two, is this in line with our international obligations, including but not limited to the Rome Statute? And if you could elaborate on that, please.
Thank you very much, Senator. So in terms of allowing for private citizen-initiated prosecutions, there's nothing specific that I'm aware of. Perhaps others might have ideas in relation to requiring or allowing private citizen-initiated prosecutions, either under the Genocide Convention or under the Rome Statute. I suppose our submission is broader in the sense that because the Attorney General's consent requirement at the moment provides a significant obstacle, that possibly could be problematic from an international law perspective. The issue of allowing private citizens is more of a, it's a right under various Australian laws that private citizens should be able to initiate prosecutions. And sort of following on from what Professor Williams was talking about, we already have robust kind of provisions in place, particularly under the Commonwealth DPP Act, and the fact is that allows and supports for private prosecutions, and it prevents from any sort of vexatious issues as well. So the Commonwealth DPP can take over these sorts of prosecutions or these sorts of initiated investigations, and that's where I see they can take into consideration things like international, potentially other immunities, not just head of state immunities. They may be able to take in resourcing factors, evidentiary factors. And so it's definitely, we already have, I think, a system in place that works for both, the Australian laws that we have and the international law obligations as well. So at this stage, I think the private prosecution aspect is perhaps not something that is required or under international law, but because of the Attorney General's consent, we are sort of already narrowing the pathways for prosecutions in Australia, and we should be broadening them.
Ms. Hood, did you want to comment?
I think it's been well covered. Thank you, Senator.
Thank you. Again, to Dr. Cormier and Dr. Hood, you argue that private citizens should be able to initiate prosecutions, but there should be a role for the AG to stop proceedings if the person charged is entitled to head of state immunity. Can you tell me why that is?
Yeah, that's just because under international law, under what we call customary international law, it's an absolute immunity. It's procedural in nature, but it's an absolute immunity from domestic foreign jurisdictions for current sitting heads of state, heads of government, and foreign ministers. It's something that at this stage there does not seem to be any movement away from, and so it just means that while those three individuals, it doesn't go beyond those three, while those three individuals are sitting in their particular positions while they're still in power, they cannot be subject to the sort of domestic criminal proceedings, even initiating them in foreign domestic courts or jurisdictions. It's potentially a different matter for an international court, but it is something that there, at least in my kind of research and knowledge, there really is no exception for this, even for international crimes at this stage. And so It is something that I think if there was potentially some movement towards prosecuting a visiting head of state, foreign minister or head of government, it could be quite problematic from both a political and a legal perspective. So that is probably the one area that we think the Attorney General has a political right to step in and say, no, this cannot happen at this stage.
And Senator Thorpe, I'll just let you know if you've got one more question, and then I'll have to hand over the call, or one or two if you can squeeze them in. Thanks.
Yep, thank you, Chair. Just one more. So are you aware of any other jurisdictions that do have an Attorney General's fiat? And if so, which ones?
Should I answer that one? So I think the one with which I'm most familiar is the UK has a similar provision. I've been looking at that. They seem to, so they require the consent before prosecutions can be initiated. It's not just on genocide, it's on international crimes and a couple of other international crimes, including some of the corruption offences and things like that. But it is used for genocide and other international crimes. What they have done over the past 10, 15 years is try and clarify the relationship and the role of the Attorney General in relation to these prosecutions, recognising that the Attorney General has very much a political and a legal role, and trying to clarify which hat the Attorney General is wearing when making these decisions. They've also entered into agreements between their DPP and the Attorney General to try and regulate the discretion a little bit. And then they have also adopted, which is made available to the public, a series of guidelines or guidance indicating what factors will be taken into account by both the prosecuting authorities. And I think the Attorney General will look at those as well when making that decision. So they've retained the discretion. They have put in further controls about when you can have someone arrested for these international crimes. So that requires a personal sign-off by the Commonwealth DPP, which is a lower level of consent, arguably, than the Attorney General. But they have tried to also not remove that discretion, but to restrict it through kind of more upfront and available guidance and guidelines and factors that should be applied. But they certainly have retained it.
Thank you very much. I'll hand the call over, Chair.
Yeah, thanks, Senator Thorpe. Senator Scarlett, do you have a question?
Yes, I do.
And then I'll come to you, Senator Shoebridge.
Thank you very much. Can I first, before I forget, can I ask the witnesses to take on notice, if you could please read the submission made by the Attorney General's Department, which makes a number of points in relation to these offences. It covers matters such as, for example, the reason for the law being as it is at the moment, including the public interest factors the Attorney General needs to take into account, provides examples of those public interest factors. It deals with the position in overseas jurisdictions. It mentions New Zealand and Canada in addition to the United Kingdom as jurisdictions where the consent of the attorney is required. It also deals with coordination with other processes, issues around appropriate forum, and also issues relating to possible reviews of decisions and also retrospectivity. So I'd be interested in your views with respect to those arguments made by the Attorney General's Department. I'd also be interested in your views with respect to the existing guidelines of the Commonwealth Director of Public Prosecutions. So the existing guidelines do contain provisions relating to how to proceed with matters where there is an issue of ministerial consent, attorney consent, and there's also policy outlines with respect to, or policy principles with respect to the issue of private prosecutions and the ability of the Commonwealth Director of Public Prosecutions, as I'm sure you're all aware, to intervene, take over a prosecution and decide to, in certain circumstances, decide not to, after it takes over a prosecution, deciding not to proceed with a prosecution. So interested in your views with respect to how that all works in the mix, because we did talk about guidelines. The first question I have is, as I understand it, looking at this issue from an overarching perspective, the Statute of Rome sets up the International Criminal Court, and it is within the jurisdiction of the prosecutor of the International Criminal Court to receive information with respect to alleged offences falling within the jurisdiction of the International Criminal Court, and to actually commence proceedings under the Treaty of Rome, under the Statute of Rome. So that might occur in different circumstances, but it could occur in circumstances where a state party was either unwilling or unable to bring proceedings within a domestic jurisdiction. So is it true to say there is that check and balance in the current system where the International Criminal Court has the ability to bring proceedings of its own motion through its own prosecutor?
Should I step in for that one? So I think that is correct. The way I choose to look at it, though, is that Australia, as a state party to numerous conventions, including the Genocide Convention, has signed up to prosecute international crimes, particularly where they occur on its territory or involving its citizens. And so, in a sense, the states should bear the primary obligation, and the International Criminal Court is intended to be a kind of backup or a secondary jurisdiction. So we shouldn't be relying on the International Criminal Court to meet our international obligations for us. In any event, we all know the International Criminal Court has a huge number of cases potentially on its docket. It has limited resources. I think it would be unrealistic to expect that the ICC will step in every time that international crimes are supported. And so, in fact, if the international criminal justice system is to work effectively, it really does require states like Australia and other states to step in and to take some of that burden from the court in terms of domestic prosecutions, both of our own potential crimes perpetrated here or with our citizens, but also to do our share in terms of universal jurisdiction cases, like we see many of the European states are starting to do, particularly in relation to Syria and other situations around the world. Thank you.
Okay, I'll just ask some follow-up questions in relation to your answer there before I give other witnesses an opportunity to respond. However, it is the case, isn't it, that in terms of the public interest factors to be considered by the attorney, one of those factors is appropriate forum. So there are over 100 signatories to the Treaty of Rome, to the Rome Statute. Clearly, if there are alleged crimes which fall within the purview of the statute, which occur in a country other than Australia, and maybe that's the first category to consider, it doesn't make sense for there to be 100 prosecutions in 100 different countries with respect to the same crime. If prosecutions are launched or proceedings are occurring in the International Criminal Court, that would be an example, wouldn't it, of something which the attorney should legitimately take into account as to whether or not to grant consent to prosecutions being initiated onshore?
Yes, certainly. And the list of factors we would suggest would definitely include looking at where alternative prosecution fora may be. I think, particularly for those that don't have that connection to Australia, we could look to other countries. So it's not just the ICC, it's whether other countries are also prosecuting. And there is, I think what we should be involved in then is some of these more global efforts at coordination in terms of making sure that these crimes get prosecuted somewhere. And that's preferably where there's a stronger territorial connection, it's easier to get evidence, or through the ICC if they are going after the kind of senior leaders or those most responsible. So in a sense, we've also got to look at whether you're prosecuting the leaders or if you're prosecuting direct perpetrators, so those who've actually pulled the trigger and committed the rapes and things. So, for example, the Eurojust system is working, I think, quite effectively in relation to crimes from Ukraine, and that's a system of several European states working in tandem with the ICC in relation to crimes coming out of the Russia-Ukraine conflict, and they are looking at coordinating which states are taking on prosecutions and making sure the right evidence is shared. So I think, yes, definitely that should be one of the public interest factors that is considered, which other venues are available. But also we should consider issues like what kind of cooperation is available, where the evidence would come from, what role Australia could best play in relation to these different types of prosecutions.
So just in relation to that, just flowing on from that helpful answer, it is the case, isn't it, that there are obligations under the Treaty of Rome, under the Statute of Rome, for Australia to provide assistance to the International Criminal Court if the International Criminal Court seeks assistance from Australia. That's correct, isn't it?
Yes, that's correct. So we'd also have obligations under mutual legal assistance treaties and other treaties for international crimes that talk about states cooperating. So we would also have obligations to cooperate to assist prosecutions elsewhere.
Okay. Can I give our other expert witnesses an opportunity to add anything to that answer before I move on to my next question? No? It's okay. In terms of, I've been reflecting on this issue of an appeal against an attorney's decision as to whether or not to proceed with bringing charges or laying an indictment. How do you appeal a decision which takes into account, and I think we're all on the same page here, such diverse matters as foreign interests, national security, a whole plethora of matters which need to be considered by the attorney. Some of those matters he or she may well be privy to information which is not in the public domain. They might go to issues of international comity. Might go to undertakings or discussions the government of the day has had with other jurisdictions, for example, in the circumstances you've raised as to whether or not other jurisdictions are in the process of compiling evidence to bring charges, which is not currently in the public domain, and they don't want to prejudice the investigation. There's just a whole plethora of matters I can envisage that need to be considered. How do you envisage a judicial review, if you like, of that decision being made in those sort of circumstances? It seems it would be very unusual from my perspective to have judicial review made of an attorney's decision in that situation, wouldn't it? Just as it would be to have judicial review of the Commonwealth Director of Public Prosecution's decision to bring decision as to whether or not bringing charges is in the public interest. Is that a fair comment?
I'll respond to that one unless you would like to. So we did consider the same types of considerations, which is why we haven't given detailed proposals in terms of judicial review. We looked, given our main option that we supported was replacing the Attorney General with the Commonwealth DPP. Of course, we have jurisprudence here that says that those decisions aren't judicially reviewable. I think there would be concerns about what the scope of the review would be, whether it would be, I think our view is if there are at least some reasons provided and some information provided, and there's also an identifiable set of factors that are applied, the review would be effectively looking at whether the process has been followed, whether the attorney has at least taken into account those factors. I think we would all agree that because of the nature of the factors you've mentioned and the types of evidence the attorney might be considering, there might be what we'd call a large margin of appreciation to the attorney. And so it would probably only be if it was clear that that process hadn't been applied, those factors hadn't been taken into account. So in effect, if it was entirely irrational type of decision, then we would be looking for that to be reviewed. But I think the scope of the review and the body to review it, in our submission at least, we weren't so decided as to where that should be, recognising the challenges of reviewing these types of decisions.
And just one final follow-up question just on this particular point, and then again, thank you for your helpful answer. The Commonwealth Director of Public Prosecutions, and I had a quick read of the guidelines that they have in relation to these issues where there's ministerial consent, and it does talk about consultation with relevant government departments. So you're almost, in a way, you're going to get to the same situation of the Director of the Commonwealth Director of Public Prosecutions isn't necessarily going to know all the things which a Cabinet Minister is going to know with respect to issues around international comity or issues around foreign relations. Again, this almost unlimited list of things the attorney's going to have to take into account. So wouldn't it just be a case the Commonwealth Director of Public Prosecutions is going to liaise with the Attorney General's Department in any event, in the Department of Foreign Affairs, and you're ultimately going to get to the same position in the vast majority of cases? Is that a fair comment?
Yes, indeed. I think another recommendation we would have had would be that we establish some kind of coordination committee across those different ministerial responsibilities so that the Commonwealth DPP has all that information. I think for us, and bearing in mind, our submission is really only talking about retaining Attorney General consent and or DPP consent for universal jurisdiction cases. You would end up in a fairly similar position. I think what we thought was that removing the possibility of a political actor making that decision, as opposed to having input into the final prosecutorial decision, raises a potential perception of political interference or bias. Our other concern was that if the International Criminal Court is looking at decisions from Australian bodies not to prosecute, I think the fact it's made by an independent prosecutor, albeit with relevant input from various departments, may make it look less like we're unable or unwilling to the International Criminal Court. So I think potentially taking that political role out may make our system more robust, if you like, to withstand the International Criminal Court investigation of us. And I think it looks better from a public perception that it's an independent DPP making that decision, subject to internal scrutiny within that department as well.
Okay, thank you.
Thanks, Senator Scarr. Senator Shoebridge, you have the call. We might just have to go about 5 minutes over with these witnesses. I hope none of you have a hard stop. Thanks, Senator Shoebridge. You have the call.
Thanks, Chair, and thanks everyone for your helpful submissions. One of the aspects the Attorney General's Department takes issue with is the amendments which allow for potentially retrospective judicial review of decisions taken by the Attorney General and in decisions not to prosecute. Do any of you have any views about that?
Oh, thanks for the question. I think in terms of retrospective judicial reviews, I would agree that the provisions shouldn't be applied retrospectively. And as we've just indicated in former questions, we would suggest that in future there would be some more detailed set of criteria or guidelines that the attorney should be applying. And so that should, of course, only be applied prospectively.
Is that everyone's position?
Yeah, I think we would agree as well that it's just a little bit too difficult, I think, at this stage to be trying to apply this retrospectively, and the preference would be to go forward with sort of a more robust set of guidelines or processes to guide the decision making.
And indeed, those two things go together, don't they? A set of statutory criteria or clearly established guidelines actually assist in allowing judicial review to be effective and law to be applied. Those two things go together, don't they?
Yes.
Yeah. I see nodding. Nodding turns up really badly on the on transcript.
I agree.
Yes, it does.
Sorry, yes.
No, that's okay. Of course, changing the law itself doesn't mean prosecutions happen. And you could probably look across a suite of criminal provisions where the law would permit wrongdoers to be held to account, but the lack of resources, the lack of attention by the executive arm to actually investigate means that those laws are ineffective. Do you have a view about if we did change the law, would we then need to put in place those prosecutorial investigative resources? And if so, where would they best be cited?
I'll just start very briefly and then I think I can hand over to Professor Williams. But I mean, regardless, I think, of whether this law is changed, I think there should perhaps be more resourcing put into this, this idea of investigating and prosecuting international crimes, because we haven't had in Australia so much success or even all that much in the way of investigations into these sort of international crimes where there has definitely been potential evidence of individuals living here who potentially have committed such crimes. So I think even retaining the current laws that we have, I would be in favour of perhaps increasing the resources and especially if we do change these laws, then that's definitely something I think that would help as well.
Well, just before I go to the rest of the panel, France, Germany, the Netherlands all have discrete units to investigate war crimes as part of their legal mix. They don't just have the laws on the statute books, they have discrete, highly skilled prosecutorial units to prosecute war crimes and genocide. Are they good examples for us to look to?
Yeah, absolutely. And Australia has in the past had a war crimes unit, but these things do need to be properly resourced and individuals do need to be properly trained, and there needs to be, of course, in any kind of situation where there are international crimes and international investigations, there needs to be, rules and policies in place where, cross-country investigations and cooperation, particularly in relation to things like evidence, can definitely be put in place. So I think for sure we should be looking to some of those countries and seeing how they're doing things and ideally do something similar here. Any
of the other witnesses have a view on this?
Yeah, I'll just add, so I agree. I think regardless of whether the laws change, we need to look at our domestic capacity to both investigate, but also, as Monique mentions, the ability to coordinate with other countries will be particularly important. So kind of sending off the boring stuff in terms of getting the evidence you might need for these prosecutions. But also, it's not as if we don't have a lot of expertise already available to us. We have a lot of practitioners, investigators who have worked, including on the MH17 investigation. We have people who've worked in international tribunals. There will be a huge raft of people who will be working on the war crimes investigations. So we do have the expertise, but I agree that a specialist unit is what we need. And certainly that will also require, in effect, broader governmental support, because obviously we need to be able to detect people coming into Australia who may be alleged war criminals and to detain them. So we need, in a sense, just setting up a unit and saying, go for it will not be enough. We need to have a kind of whole of government and correct funding approach so that we recognise people when they come in, so that we're liaising with foreign governments to get cooperation. But I think at least as a start, having a dedicated team, probably located within the AFP and within the Commonwealth DPP would be the best place for it, rather than a kind of separate statutory body.
Anybody else? Dr. Hodgson? Or no? Would that include the work of the Office of the Special Investigator? Do you see an argument for having those distinct prosecutorial roles, civilian/military, or Australian military/everybody else?
I think the issue with the Office of the Special Investigator is that its role, and others correct me if I'm incorrect on this, is really to regulate the flow of evidence from the Brereton inquiry into the prosecution. So it's filling quite a specific role, which you wouldn't need in these broader prosecutions for international crime. So I think a model of having a team, a standalone team with a separate budget and high quality staff like the Office of Special Investigator would be a good model, but I don't think you could blend this function into their function, because they're doing something that's quite discreet and quite unusual.
But if I understand your united position is, regardless of whether or not this bill proceeds, that's work the Commonwealth should do to establish that professional continuing team, either within the AFP or in a standalone unit, so that the skills are retained, the international connections are made, and our laws can be effective. Is that right?
Yes, definitely.
Yep. I just note the time.
Thanks, Senator Shoebridge. I just have a few follow-up questions, if I may, in the very short time that we have left. I note I think there was a discussion with Senator Scarr, some questions about other comparable democracies that require Attorney General consent, and there was a discussion about the UK. I've got Canada and New Zealand among others. Professor Williams, have I got that right? The Attorney General from the UK, Canada and New Zealand, and there's other comparable democracies that also have a consent of the Attorney General required for these types of prosecutions.
Yes, as far as I'm aware that they do. I was just more familiar with the UK because I practiced over there.
Oh no, that's very helpful. Thank you. There's other criminal law, and this might not be an area of your expertise either, that I'm just asking to understand where this sits in comparison to other provisions. There are other provisions in Australian criminal law that require the Attorney General consent for prosecutions. That's right, isn't it?
Yes, there are. I can't pretend to be across all of them, but they do tend to be these types of crimes that have an international dimension, or there's some particularly complex element to them. So I think from memory, corruption, a couple of other international crimes, but it's not something I'm fully across.
Yeah, they sort of tend to be in relation to perhaps overseas jurisdictions or crimes at sea where there might be an international component to the prosecution. Just in regards to both of your submissions contemplate private prosecutions being brought forward. In that scenario, even if the Attorney General's consent was not required for such prosecutions, what is the usual approach of the DPP? As I understand it, that she would ordinarily use her power to take over and possibly even terminate a private prosecution. How does it work at the moment? So putting aside the consent of the Attorney General, how does the DPP handle private prosecutions?
So as I understand it, they will review the evidence and the public interest factors as they would if they were bringing the prosecution themselves.
Yep.
If they decide it would be better for the Commonwealth to bring the prosecution, they would step in and take over the prosecution, and it's as if they'd initiated it and they would run that case themselves.
Yep.
If they decide, and it's usually in the case of vexatious or perhaps where the evidence isn't available, they can step in and decide to terminate the prosecution. I'm assuming that in relation to those decisions, they're also applying their own guidance in relation to communicating with victims and consulting with victims and things to get the victims' views on those decisions as well. But that's how I understand it. Obviously, a lot of these decisions aren't publicly made in terms of reasoning and things, but as I understand it, if they think the prosecution is vexatious or doesn't really have a chance of succeeding, they can step in and end the proceedings at that point.
Right. And I'm just interested in how this will work practically, and you may or not know the answer, but if we're thinking hypothetically how this might work, if the Attorney General's consent is not required for such prosecutions, would that increase the workload of the DPP to essentially consider these types of cases? I mean, you said that they have to put themselves in the shoes of the investigator and investigate the case as if they were the prosecutor and then make a decision. So is there a flow-on effect to the DPP if there's I'm just thinking maybe the Attorney General's consent prevents that sort of on-flow of happening of those vexatious claims?
I think in a sense perhaps, so the two issues are in a way distinct. So if you have private prosecutions, that is where you might see an increase in cases being brought, so it might have an impact on both the courts and on the DPP in the sense that if you have private prosecutions and you remove the requirement for the Attorney General's consent, then yes, I can foresee quite a number of applications being brought before Australian courts, and we've seen that happen elsewhere where there's been quite flexible and unlimited universal jurisdiction provisions when they're combined with the right of private prosecution. We've seen some jurisdictions have moved to restrict that right to stop that kind of flow of cases. If you kept the right of private prosecution and either a consent requirement for the Attorney General or the DPP, I I think they could step in and stop them sooner if needed. I think it also goes as to who we think should be bringing these cases. My personal view is that these should be brought in the name of Australia, not as private prosecutions, because we are effectively doing our duty as good international citizens to bring these cases. So my personal view is probably to lean against private prosecutions. I think if you put the requirement on the Commonwealth DPP rather than the Attorney General, in reality, they will be doing about the same amount of work than they would if it was coming to them without private prosecution, because they'd still have to investigate the evidence. I guess the situation, they have control of the prosecution from the outset, so they have more control over which evidence is being obtained. They can get evidence through official channels and also through civil society. So I think that is the risk if we remove the Attorney General's consent requirement or any kind of consent requirement, and we reintroduce the right of private prosecution. The risk is we get a flood of these prosecutions or potential cases coming into Australia. So I do think we need to modify or kind of moderate that risk to an extent, which is why we suggest the Commonwealth DPP having that consent requirement.
Okay, thank you. I guess, and sorry to get hung up on private prosecutions, but it is, I'm thinking forward to some of the witnesses that we have coming up and some of the other submissions that we've received, and just trying to understand how that might work in practice. It wasn't clear from your submissions, I don't think you contemplate it, but do you support private prosecutions for any other crimes?
I haven't really thought beyond the international criminal aspect. And as Dr. Comey has mentioned, that the right is there. It was just because of the wording of this particular provision that is being now repealed that the High Court said private prosecution didn't exist. So it is, if this provision is repealed, then the issue is open for interpretation again, I guess is our point. We were looking at whether or not, I think particularly for universal jurisdiction cases, my own personal view, and part of the reason it's not our submissions, I don't think we necessarily agreed, is that I would prefer to see more of a system where there's quite a structured way for civil society organisations and victims to get information to the prosecutor, and then the prosecutor would bring those cases rather than recognising private prosecution. That's my personal view on that. Some of my co-authors may disagree.
Well, I'll allow them to provide a different opinion. Otherwise, I need to move to our next witnesses. Apologies. No. All right. Well, thank you.
Sorry, can I just quickly come in and build on what Sarah said and in particular reflect back on perhaps the risk of an increase in private prosecutions if the law were to change? Because I do think I would like to make 2 points in addition to what Sarah, Professor Williams, has said. First, I would suggest perhaps that rather than necessarily seeing the potential of private prosecutions as a burden, we could also think about what civil society could contribute to our justice system. And when we have civil society organisations working closely with diaspora communities, with refugee communities, who are able perhaps to access evidence that state prosecutorial agencies cannot, private prosecutions might actually be a benefit to the justice system. The second thing I would say is I think there are other systematic factors that perhaps operate to limit the potential for frivolous or vexatious private prosecutions to be brought. And I'm thinking in particular that private prosecutors can be liable for costs orders for a failed prosecution. So if you bring a private prosecution and you're unsuccessful, you might need to pay the other side's costs. And they might also be open themselves to a claim for malicious prosecution. So I do think there are other systematic safeguards that might operate to prevent a flood of frivolous or vexatious private prosecutions if the law were to be reformed. And I would encourage the committee to think about not just how we balance and respond to potential risks, but also what benefits opening up private prosecutions might bring.
Thanks, Dr. Hodgins. I think I was probably thinking more about the vexatious type. You weren't probably privy to the inboxes of senators during COVID-19 lockdowns, but we received a lot of arrest warrants for trying to protect people's public health. So I was thinking more about those types of vexatious claims. Thank you very much for appearing. Oh, sorry, you wanted to add to that, Doctor?
No, the only other thing I would add is there is actually also a, I guess, very preliminary safeguard against that, which is when a person goes to file their private prosecution, to file the implementing processes, the registrar of the relevant courts actually has to sort of assess what has been filed and confirm that it alleges, crimes according to law, and that can be referred to magistrates for further review. So even at that very initial stage of the process, before we get to a point where, the Director of Public Prosecutions might be in a position to take over and discontinue prosecutions, there are also procedural safeguards. I have absolutely no doubt that you received all sorts of allegations during the pandemic, but I think it's important to think about this in its procedural context and the safeguards that might exist at various stages to limit the potential for vexatious claims.
Sure. Like the consent of the Attorney-General being required. Thank you very much. That's all the time we have, and thank you for giving evidence today. I think you were asked to take some questions on notice, so we'll let you know about the date to return those to us, but we should have enough time for you to really digest that Attorney-General's submission. Thank you very much. I now invite our next witnesses. And thank you for your patience while we were just finishing up with those witnesses. We have two witnesses on the next panel. I now welcome Uncle Robbie Thorpe and Mr. Len Linden, who are joining us via video conference today. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and protection of witness and evidence has been provided to you and is available from the Secretariat. Witnesses are reminded that if they give evidence that reflects adversely on another party, the committee is generally required to give the party reasonable access to the evidence and an opportunity to respond. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today? Oh, you're just on mute, Uncle Robbie, unfortunately. I think Mr. Linden is with you.
How are we going there?
Yep, we've got you now. Thanks, Uncle.
My name's Uncle Robbie Thorpe. I'm here at Camp Sovereignty. As I say, thank you for the opportunity to have an opportunity to answer a few questions here today.
You're very welcome. Thanks for being with us.
And I'd like to introduce you to Len, who's going to read out an opening statement.
Okay. I'll just get your name for the Hansard record, Mr. Linden.
Yeah.
Thank you.
If we can drop the Mr, it's just Len Linden, L-I-N-D-O-N.
Okay, well, Mr. Linden, I'm the chair of the committee and I'll refer to you as it's written in front of me. I'm just trying to be courteous and work with what's in front of me, so I'll continue. I'm going to invite you to make an opening statement briefly before we go to questions. If you've got that now, we'll go to you and then we'll go to questions from senators. Thank you.
Yeah, this is my opening statement. Len's going to read, because I've problems with my eyes. It's difficult to read.
Okay, thank you.
Okay, welcome to Camp Sovereignty. This morning we welcome members of your Australian Parliament here to our sacred fire, to our ancient law. Just over there is the resting place of 37 skeletal remains of First Peoples returned from the Victorian Museum and other government institutions. And so we welcome the 7 committee members and the 58 participating members of this legislation committee of the Senate of the Australian Parliament. See the attached list at page 4 from the Australian Parliament House website. We now invite the prosecutor of the International Criminal Court to Camp Sovereignty to bring an investigative team from the Office of the Prosecutor to come to Camp Sovereignty urgently under Article 17 of the Statute of the International Criminal Court, which is Schedule 1 to the International Criminal Court Act 2002 of the Australian Parliament on the Federal Register of Legislation online as a reference. Australia is demonstrably unable and unwilling to investigate and prosecute the crime of genocide against us, Robbie's people. And so under Article 17, the International Criminal Court now has jurisdiction to investigate and prosecute Australians for the crime of genocide. Under Article 25, complicity in genocide is genocide. Article 27 states that, quote, official capacity as a member of Parliament shall in no case exempt a person from criminal responsibility, nor shall it constitute a ground for reduction of sentence, unquote. Question: can senators who have not attempted to remove section 268(1)(21) be charged with genocide in the International Criminal Court? The purpose of the International Criminal Court is, quote, to put an end to impunity for the perpetrators of these crimes and thus to contribute to the prevention of such crimes. That's the preamble of the statute. Under Article 5, genocide is a crime within the court's jurisdiction and defined as killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, and forcibly transferring children of the group to another group. Every one of these acts has been committed against us since the English War of Military Invasion began against us. Each of these acts has continued to be committed against us in every generation since the invasion started. The motive was to steal our lands, waters and skies. The intent was to usurp our law. This multi-generational genocide has continued from 2002 until today and will continue tomorrow and into the future. There has been no treaty since 2002. There has been no official declaration of the end of hostilities since 2002. No one has ever been prosecuted since 2002. Article 30 states that intention in relation to conduct means to engage in a conduct, and in relation to a consequence means to cause that consequence or be aware it will occur in the ordinary course of events. And knowledge means an awareness that a circumstance exists or a consequence will occur in the ordinary course of events. Parliamentarians intended to make section 268(1)(21) part of your law. Parliamentarians intended not to remove it from your law. Parliamentarians intended not to recognise our sovereignty. Parliamentarians intended not to seek our consent under a treaty. Question: will the International Criminal Court convict you of complicity in our genocide? Article 77 penalties include imprisonment for life. Article 53 requires an investigation by the International Criminal Court because, quote, there is a reasonable basis to believe that a crime within the jurisdiction of the court has been or is being committed, unquote, and taking into account the gravity of the crime and the interests of victims, there are, quote, no reasons to believe that an investigation would not serve the interests of justice. 30th of July 2004, Uncle Robbie Thorpe, Camp Sovereignty, crimesceneaustralia.com. Attachment, email on Friday 26th July at 12:22 p.m. of Camp Sovereignty submission to the committee and page 1 of the 34-page submission. That's the end of Robbie's statement.
And I'm prepared to take any questions that you may have.
Thank you so much, Uncle Robbie. And the picture's a little bit shaky. It's going in and out. So when we get to questions, when we're asking questions, I'll just see if we can keep that camera as still as possible. I know it's hard and I appreciate you joining us from where you're joining us today. I'll hand over the call to Senator Thorpe, who I believe has some questions for you.
Thank you, Chair. And thank you, Uncle Robbie, for appearing today, given you're fighting an ongoing genocide in our own country and standing up for our people relentlessly. My first question is, why do you think the so-called Attorney General's fiat exists?
Because it's part of the, to me, it says Australia's unwilling and unable. And it's basically an apparatus. I don't think it exists anywhere else in the world. I think Australia's the only place in the world where that exists in terms of international law. They have this thing called a fiat, which is basically a means to prevent people like ourselves in accessing these courts. So it indicates it's a barrier, a blockage, a means to our claims.
We just lost you there for a minute, Uncle Rob. I just want to, we heard earlier evidence that all the colonised countries actually have the same Attorney General's fiat. So wherever the colonisers are, they've actually put this fiat in place. So Canada, the UK, and I think it was New Zealand and here. So the colonisers must have got together at some point and said, let's do this. So just for your information.
Yeah, that seems very predictable. That would be the case. And that's since 2002, they've added this fiat into the process. It's not actually, it doesn't suggest to me that it's in any way a means of preventing things. It's a way of preventing people from actually preventing things. So it's wrong in their law, and it needs to be questioned. And that's why we're here today, I suppose, how that could be possibly part of their law. When the issue of jurisdiction is universal, there's no statute of limitations, and no one's immune. So why is there a fiat to begin with? Why do they need to have a fiat? Any of these countries. It's very clear. It's so obviously clear why they've got that there, to protect their stolen wealth and their interests there.
Mm. So do you think that the AG's fiat is compliant with the universal nature of the Genocide Convention, which should apply across jurisdictions?
I think it makes total mockery of the law when you've got an individual who's able to stand in the way of this universal law, where it's meant to be accessible to people. So to have a fiat there, it says something's wrong with this country's law. They're unable and they're unwilling to deal with this issue. They need to have a fiat, an individual standing in the way. It's another barrier, so it's another means of blocking our people. It's nothing new, but we're determined to go to the International Criminal Court for whatever it takes. So, and I think if it is looked at properly, there's no way that could stand up in international law as well. And I think that this issue is going to come to the fore in the coming months. How is it possible? I don't know what the situation is in Palestine. Do they have an Attorney General or someone blocking them from accessing these courts? So, how is it fair? How is it fair at all that we've got this individual, a coloniser to this land, an invader, a trespasser? He's got the ability to block us accessing these courts. That's totally wrong in anyone's sense of law.
So genocide, just going on to my third question, genocide is the worst of all crimes. The 1948 Genocide Convention came about to prevent genocides from occurring wherever it might be. And I believe not a single case of genocide has been pursued in Australia courts, despite several genocides having taken place internationally since 1948 and some obviously occurring today. The urgency to act couldn't be greater, as we can currently see in the case of Gaza, with more and more people losing their lives every day. Do you think so-called Australia is failing to fulfil its international obligation to prevent genocide?
Totally, utterly. If you have a look at the Genocide Convention and the definition of it, Australia is guilty of everything defined as what genocide is, according to the 1948 Convention. And I'll challenge anyone from that Senate or any of the committee and inquiry here to say otherwise. Have a look at the Act. They're guilty of everything written in it. And the fact that they haven't legislated and made it an offence in this country is tantamount to committing the crime itself. They're failing to prevent. The whole spirit of the 1948 Act was the idea of preventing the act of genocide and punishing people for it. That never happened. There's no deterrence from people committing in this country. That's the whole idea of it, preventing the act. Now, it's very clear that Australia has failed to prevent. We still have issues of stolen generations. If you have a look at the stats, the issues are worse. Deaths in custody, creating the conditions of life, all of it, the whole act, you're guilty of. So I'm challenging that this committee and Senate to demonstrate otherwise. What part of the act you're not guilty of?
So just on that, Uncle Rob, you have repeatedly tried to pursue genocide cases within the existing colonial legal framework. Can you tell us a little bit about your experiences with that?
Well, when we initially tried to evoke that act, we were told that genocide was not considered to be an offence in this country. That was in 1997. Since that time, the International Court, the Rome Statute and the creation of the International Criminal Court of Justice has been established and Australia signed on in full. Where this fiat comes from, I fail to understand. I don't know if that was part of the negotiations, the immunity deal that Australia did with the courts. They've got a habit of doing that. They did it back in 1948 and they got away with, for, I think it's 76 years now, that genocide was identified back then and nothing's happened. It's got worse. Have a look at the stats here on it. You think there's a war going on. By the way, you know, when a fleet of military ships turn up in your territorial waters, it's an act of war and aggression. Started 250 years ago here. When did it end exactly? So the issue is there a war going on in this country? Is there a war? And when did it end? Exactly. Has there been a cease of hostilities? How is it possible for these people to be sitting there in judgment of our people? We have a law here. White colonisers came here. They didn't bring law here. They brought terrorism and piracy. They're not a law. They're a falsehood and needs to be exposed at the international court level. There's no way that we're going to get justice in this country. So we need to do this. It's urgent. It's not just urgent for Aboriginal people. Australia's complicit with other genocides around the world. So it's urgent on many fronts. And the noose is tight. You know, you may have got away with it for the last 76 years, but things have changed. So, and we're not going away. We're going to be here until we get justice for our ancestors, for our esteemed elders, our children, our children's children, and our land. So you better deal with it. And what that statement said is you better consider what you're saying here, because you're complicit. That's why we need to have this at an international level. We can't have an in-house arrangement here in terms of this genocide laws. That's why the whole idea it's international universal jurisdiction should apply.
I'll have one more question before I pass on, Chair, if that's okay.
Of course. Thank you.
So, Uncle Robbie, you have just last week lodged a private criminal prosecution with the Magistrates Court of Victoria against the Federal Attorney-General Mark Dreyfus, alleging that he has failed to stop and prevent the ongoing Aboriginal genocide. And I can vouch for this because he refuses to implement the Royal Commission into Aboriginal deaths in custody recommendations. He has the final say on that and he refuses to do that. He gave us the count of body bags during the referendum time. We were meant to be grateful for that. So I concur with you on this statement. Can you please outline why you believe this is the case, that the Attorney-General, Mark Dreyfus, is complicit here? and what you think the court will accept in relation to the charge sheet.
Well, I think, like I just said, the Attorney-General has his fiat, and it's basically preventing Aboriginal people or anybody else from accessing these courts. And I thought that Australia was the only case, but it's, like you say, it's all these colonial countries around the world have got this fiat. It makes it very clear what's going on here. So, we need to get to a court of law. Australia's not a proper legal system here. It's a falsehood, it's a fake. How do you get law when you commit acts of genocide and steal things? That's not a basis of law. Terror analysis is a legal fiction. So where do you actually get jurisdiction anyway to hear these things? So to put these people in front of us, it's preventing us remedying this situation, stopping the genocide of our people. So they're clearly responsible. Mark Dreyfus is clearly responsible in terms of their legal system. He's the blocker here. And, we'll find a way around these fiats and we'll expose this country for what it's doing. And sooner or later, it may take another 20 years, but we'll be here still asking the same question. And the weight of evidence building against this country, it's pretty disgraceful as it is. We want an opportunity in the International Criminal Court. Like, we're a law. Where's your law, white fella? Right? You're a joke. And this whole place is premised on lies, deceit, fraud. Of course you're going to back it up with your fiats and your way of avoiding justice for our people. That's all it is. You should have a good hard look at yourselves.
Thank you, Uncle Robbie. I'll pass it on to some other senators to ask questions.
Okay, thank you, Senator Thorpe. Any other questions? Senator Scarr? Thank you.
Thank you, Chair, and thank you, Uncle Robbie, for appearing today, and thank you also to Len for also appearing. Can I just ask, Len, are you the Len who's referred to in the 1997 High Court as assisting Uncle Robbie all the way back 27 years ago in the High Court?
Yes, it's the same Len.
There you go. That's extraordinarily impressive. Obviously, you're a very, very strong team in terms of advocating the way you've been advocating.
I consider him one of the best lawyers. Not that he is a lawyer these days. He's a retired barrister, but he's got a history of human rights, defending human rights, not just here but elsewhere around the world. And I was fortunate enough to catch up to him, and we've been a team ever since. But we're not that's all we are. It's just me and him doing this stuff.
No, I get it. And 27 years later, here you are again. So, can I ask you just, and Len, feel free to also assist in answering the questions. You brought Uncle Robbie, you brought the claim in the Magistrates Court in Victoria. As I understand it, and I just wanted to get this right for the Hansard, the Magistrates Court refused to accept the claim, but you then had the opportunity to argue that in the Victorian Supreme Court. Is that correct?
That's correct, yes.
Yeah, and you had your argument in the Victorian Supreme Court. It was just in the last few weeks, wasn't it?
A couple of Fridays ago. It was probably a bit more than a week ago, maybe. But I think we're waiting for the ruling and what comes out of the Supreme Court, but pretty confident that the magistrate erred when they said that the crime was not known, and they know full well it was. So it'll be interesting what does come out of that. Genocide's a known crime these days, since 2002 in Australia.
Yep.
They got away with that back in the day, but not now.
Yeah.
So they've obviously made a mistake there. So hope that judicial review uncovers that and plays that the right way.
And you argued your case in front of the Supreme Court judge in the Victorian Supreme Court, is that correct?
Yes, that's right.
And the judge has reserved her decision, is that right? So she's thinking about her decision. Has she given you any...
Right.
Sorry, that's correct?
Yes, that's correct, yes.
Yeah. Did she give you any indication as to timing when she'd be giving her decision?
Not really, but she said we gave her a lot to think about. So, well, I think it's time for a change in this country. Yeah, this law's finally caught up to Australia. Their last refuge is this fiat that the Attorney General holds. Once we get around that, I think it opens it up. And talk about our claims being vexatious and frivolous. Well, I'd ask any Aboriginal person in this country whether they reckon our claims are frivolous or vexatious. Any Aboriginal person. And I think it's really offensive and insulting to say that to our people. So, time's come on this stuff. And as you can see, what's going on around the rest of the world, things have been, there's been watershed moments recently in the genocide issues. So it's only a matter of time before the eyes of the world turn onto Australia and uncover the real history here, which is one of a total genocide from the get-go. It was premeditated, it's intentional, and it hasn't stopped. And the evidence is all there. Just look at the stats on Aboriginal people in this country. We were a robust, healthy society not that long ago. The population of the people in Nicaragua was reduced from 100% of the population to about 0.1% of the population. If that's not genocide, well, I don't know what we're talking about. I don't know why I'm here. But as far as I'm concerned, Australia's just one big legacy of shame. And if you look at your whole foundation of your occupation here, terra nullius, what did the High Court say about that before they struck it out? They said it was the act of unutterable shame. When they removed terra nullius, where did the High Court actually get the jurisdiction from? Still wondering how they worked that out. So there's lots of questions we need to ask, fundamental legal questions of international law. We're not going to see justice here while this status quo is here. And I hope that the Senate and this inquiry can do something about sorting this law out in a real way, a proper way, so we can all, we should be free from these crimes.
Thank you.
We should have a better cause.
Thank you, Uncle Robbie, and thank you to Len as well. And I'll leave it there, Chair, so other senators can ask some questions.
Thank you, Senator Shoebridge. You have the call.
Thanks, Chair. Thanks, Uncle Robbie, for your submission and your assistance today. One of the core issues you raise is that the Genocide Convention requires Australia not just to not actively participate or assist a genocide, but to actively seek to prevent genocides, whether in Australia or anywhere on the planet. And do I understand you to be saying having this bar to prosecutions works against that obligation to prevent genocide?
Sorry, what was that? Just repeat that.
Well, if Australia's going to live up to its international obligations to seek to prevent genocide, then it shouldn't have things in the law that stop prosecutions.
Yes, that's exactly. Yeah, that's the case. And why is that the case? Is Australia afraid to get out there in an international criminal court or at an international level? Yeah, Australia's international, its acknowledgement of international law is pretty dismal, and it doesn't play out only when it suits them. These are pretty fundamental laws, genocide, and you think people would be proactive on it, doing something about it, but they're not. Australia's clearly unwilling and unable to act on this.
Yeah.
So that makes, Australia's a pariah state. And it's been getting away, it's been out of sight, out of mind from the rest of the world for, you know, they've been able to do that for so long.
Yeah, and
time has come on.
And what you say and what your submission says is that far from having laws that are designed to prevent genocide and would, you know, provide sensible, practical ways to hold people to account if they permitted genocide to happen, this thing with the Attorney General is just like a political kill switch on the law. Is that your position?
Yeah, exactly. Why is it necessary?
Oh.
Why is it necessary to have that person sitting there with the ability to do that, prevent us from accessing these courts? What's Australia so afraid of? How many times they've had frivolous and vexatious thrusts on the Genocide Convention recently? That's all talk. You know?
And Uncle Robbie,
Go on.
some people have said, well, instead of giving it to a politician, the job to make this decision, it might be better handing it to the Director of Public Prosecutions, who at least isn't a politician. Do you think that would be an improvement?
Isn't it the normal process?
For many other criminal offences, yeah, that goes through the Office of the Director of Public Prosecution.
You think that'd be just the normal process of doing that, wouldn't it? Now, we've got claims that there's been a crime committed here. We've got to dance around all this politics to get to that point. And you've got this Attorney General, the highest lawman in the country, sitting there with the ability to stop us. It says something, Australia's afraid of something. And that's why they've got those people there. That's the only reason they're there.
Yeah.
Why don't stuff happen?
Yeah. Thanks, Uncle Robbie. I understand your position.
Thanks, Senator Shoebridge. Uncle Robbie, I just have two questions, points of clarification from your opening statement. I think it was read out, but it was your words. So if you have an answer for me, or if Len has an answer, that's fine too. Is your evidence to this committee that you'd like to see section 268.121 removed so that you can bring a private prosecution in regards to the crimes you're alleging have been committed?
I just might take that question on notice.
Yeah, sure. That's understandable. If you could, you'll have plenty of time to get that back to us. And then the second question, happy for you to take this on notice as well. Just a point of clarification. From my reading of your opening statement, and thank you for providing it in writing, it seems to me that you're inferring that senators on this committee or senators in the parliament may be complicit if they don't pass this law. You'll obviously understand that there are protections in place for senators so that we are not influenced in the way that we vote in the Senate. I just wanted to clarify that point as well. I mean,
well, not according to the Act. It's universal jurisdiction in regards to the Genocide Convention. So no one's immune. And there's no statute of limitations. So what you do say it can be used in a court of law against you. So I'd be seriously thinking about it. Australia's got a long history of genocide denial.
Sure. And you would view any senator who votes against this bill as being complicit in genocide?
I'd have to say yes.
I don't have any other questions, and I think that's all our questions from senators. So thank you very much for your time today, and thank you for your colleagues behind you who I understand are in attendance as well. And Len, thank you for being here as well. We appreciate your time. The committee is going to take a short break and suspend the hearing while we do that and return at 11:15. Thank you, senators.
No worries. Thank you.
We'll resume our hearing there, and I now welcome Dr. Olivia Ball, representing Remedy Australia. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. You are reminded that if you give evidence that reflects adversely on another party, the committee is generally required to give that party reasonable access to the evidence and an opportunity to respond. For the Hansard record, can you please state your full name and the capacity in which you appear today?
Thank you, Chair. My name is Olivia Ball. I'm here representing Remedy Australia.
Fantastic. And would you like to make a brief opening statement before we go to questions?
Thank you very much. Thanks. I would. I'm very pleased to acknowledge Ngunnawal country on which we meet, that is unceded land, and acknowledge the testimonies that have gone before us today. To introduce myself briefly, I am a Director of Remedy Australia, which is a national human rights monitoring and advocacy NGO. We exist primarily to monitor decisions from UN human rights treaty committees. I co-founded this organisation with Nick Toonan 10 years ago when we identified that there was no one monitoring what was going on in these UN treaty bodies as regards Australia, the decisions that those treaty bodies are making about Australia's human rights records, and so we monitor and advocate in relation to those decisions. And Remedy Australia is named for the right to an effective remedy, which is of course at stake in our discussions today. What merit is there in having human rights if there is no effective remedy? It is in itself a human right that we are entitled to effective remedies when our rights are violated. And our submission before you today, our written submission, has focused primarily on genocide of the atrocity crimes under consideration, and by way of example has drawn heavily on the Bringing Them Home report into the forced separation of Aboriginal and Torres Strait Islander children from their families as an example of an arguable case of genocide that has occurred in Australia since 1951, when the Genocide Convention came into effect. I don't use the G word very lightly at all. It's extremely sensitive and has a preserved specific meaning in international law, but we contend there is an arguable case. We cannot say precisely when genocide became illegal in international law. It's now, of course, customary law, but we know from the Genocide Convention that it certainly has been illegal in international law since 1951, and that convention not being retroactive, but there being no statute of limitations on such atrocity crimes, anything since 1951, any acts should be justiciable, should be punished, and that is the commitment that Australia made in 1949. It's a shame, perhaps, that the evolution of international human rights mechanisms, such as treaty committees, does not exist for the Genocide Convention. There is no treaty committee to which individuals can appeal, but of course we now have the Rome Statute and the International Criminal Court, which does that. But let's take it on face value that Australia made a good faith commitment when it signed and ratified the Genocide Convention in 1949, that it would abide by that treaty. It's quite extraordinary that that convention explicitly prohibits and defines as a form of genocide the forcible transferring of children from one group to another group. And of course, Australia was engaged by official government policy since 1937 in doing exactly that. Australia, the Commonwealth Government, ratified that treaty which prohibited doing that, and it continued to do that, as we know, for decades until the 1980s. Australia should have as with all of its international human rights treaty obligations, immediately translated its commitments in the Genocide Convention into Australian law such that it would be more readily justiciable. Our commitment under the treaty is binding but is difficult to enforce without Australian law. And of course it took until 2002 and the institution of the ICC and the Rome Statute when we finally did that over 50 years later. And of course, at issue today in this inquiry is to whether that is adequate. Whether it was certainly necessary to amend the criminal code at the time, but we've had now over 20 years of experience with that amendment. Has it been adequate? Because of the Attorney-General's fiat, we would argue no, and that we support this amendment to remove that fiat and those two clauses of the criminal code. I'm sure I don't need to impress upon you, but it is worth pointing out from the public perception of what genocide is often very misconstrued. And there are 5 categories of acts in the Genocide Convention that constitute genocide. It's not simply mass killing, but of course includes, as Uncle Robbie has outlined, serious mental harm to members of a group, conditions of life calculated to bring about the physical destruction of a group in whole or in part, actions designed to prevent births within the group, and of course forcibly transferring children from one group to another. The Bringing Them Home report and the National Inquiry in 1997 gave extensive evidence and demonstrated that these 4 lesser known, shall we say, acts of genocide are arguable from the one category of conduct, which is the stolen generations and separating children, Aboriginal and Torres Strait Islander children, from their families. This occurred for well over a century, from probably the beginning of colonisation in this country until the 1980s. And an estimate of between 10% and 33% of all Aboriginal and Torres Strait Islander children were removed between 1910 and 1970, and that means that nearly all First Nations families have been affected, often over more than one generation. It doesn't take a leap of imagination to understand or glimpse at the depth of serious mental harm that this practice has caused. And the Bringing Them Home inquiry demonstrated the lifelong impacts of forcible child removal on the people affected, both the children and their families. And arguably the conditions of life that were subjected to children in institutions and other settings after removal from their family could arguably and should be tested in court constitute genocide. The authors of the Bringing Them Home report, Sir Ronald Wilson and Mick Dodson, found that the ultimate purpose of child removal was to control reproduction. And that is, of course, one of the 5 acts of genocide prohibited in the Genocide Convention in Article 2D. One of the recommendations of that inquiry in 1997 was to legislate to implement the Genocide Convention with full domestic effect, very belatedly. And the Australian government did that shortly after, when in simultaneous with ratifying the Rome Statute, amended the criminal code. But we would argue that sections 268, 121 and 122 do not fulfil that recommendation of the Bringing Them Home inquiry, which was to legislate to implement the Genocide Convention with full domestic effect. Experience of the last 2 decades has demonstrated that this amendment to the criminal code is inadequate, so it cannot be said to have full domestic effect in Australia when people such as Uncle Robbie have been trying to bring such causes of action in Australian courts without satisfaction. Giving the Attorney-General exclusive power to prosecute has clearly failed. It's failed victims, it's failed survivors and their families, and it's a failure of justice. That is, of course, one example that First Nations people could bring, simply confined to the stolen generations policy and practice over decades. There are others, and of course we, as I think the first panels were focusing on this morning in presenting to you, the other atrocity crimes that are relevant to this amendment, and the fact that Australia is known to have harboured over 500 suspected Nazi war criminals since the Second World War. This is a finding of the Special Investigations Unit that was referenced earlier, that existed for about 5 years in the late 80s and the 90s, that Australia did found a Special Prosecutions Unit at that time, and that unit identified over 500 suspected Nazi war criminals and commenced investigations, brought 3 cases to court, but none of which was successful, and then the unit was defunded and dissolved. But Australia is also home to hundreds of others responsible for atrocities, and we should not be harbouring, if it needs to be said, war criminals and genocidaires in Australia. On this side of the Pacific, we are the alternative Argentina, where Nazi war criminals knew they could be safe and came in their hundreds, but also suspected war criminals from the Balkans, from Cambodia, from Afghanistan, from Chile, and from other places. At the time the Rome Statute and the Criminal Code was amended in 2002, the Balkans war was the source of the largest number of suspected war criminals here in Australia, many of them Australian citizens of Croatian and Serbian heritage who had gone to fight in the war and returned to Australia to a comfortable life free of justice or consequences. In the 22 years since amending the Criminal Code, not a single person has been brought to justice. I think that speaks for itself. I myself am not a lawyer. Ours is not a legal organisation. I meant to say in my introduction that I hold a Master's and PhD in International Human Rights Law, and I know that our Attorney-General's Department will argue this afternoon before you that this amendment will create procedural uncertainty. Surely that uncertainty is outweighed by the imperative to prosecute the most heinous and egregious of crimes. Thank you very much.
Thank you very much, Dr. Ball. I'm going to hand the call to Senator Thorpe to kick off questions to you. Thank you.
Thank you, Chair. And thank you, Dr. Ball, for appearing today and for your succinct opening statement. You are stating in your submission that there is evidence of a coordinated plan of different actions aimed at the destruction of essential foundations of the life of Australia's First Peoples. How does this compare to the 5 acts listed under the official genocide definition?
Our submission, as I've said, did focus on the stolen generations and draws heavily on the report from the Bringing Them Home report in the National Inquiry in the 1990s, and the conclusion of that report was to recommend that we give full effect to the Genocide Convention, precisely because it found, and on a plain reading of the report, which changed the face of Australia, I think, that there is a case to answer. That of the 5 categories of genocidal acts prohibited in the Genocide Convention, arguably 4 of those were an argument could be made that forcibly removing Aboriginal and Torres Strait Islander children from their families could constitute one or more of those categories of genocidal acts, as I've tried to outline. Namely, mental harm, conditions of life calculated to bring physical destruction, preventing births within the group, which the inquiry found was the primary purpose of removing children from their families, and of course, stated in black and white, forcibly removing children from their families is a form of genocide prohibited in the Convention. Does that answer your question?
Yes, it does. Thank you. And the fact that the government continues to refuse to implement the recommendations of the Bringing Them Home report, obviously it's an ongoing genocide because our children are being taken away at a rate that's out of control in this country today. So thank you. My next question is, what do you think the reasons for the existence of the AG's fiat is in this country, as opposed to enabling anybody to pursue cases of atrocity crimes?
I couldn't, of course, comment on the intention or the purpose at the time in 2002 of including that fiat in the amendment to the Criminal Code, but we can see in practice what it has meant, which is that no one has been able to bring a prosecution for atrocity crimes in Australia. No one has been extradited. I think that is what demonstrates that it is inadequate. I couldn't say what the purpose or intention of it was at the time, but I would like to take on face value that Australia's intention is to abide by the Genocide Convention and prosecute and prevent genocidal acts.
So do you think that there's even a willingness to investigate and prosecute crimes against humanity in this country at all? It's
difficult to conclude that there is. I'm very, very concerned at how we treat whistleblowers who are exposing serious wrongdoing and potential war crimes. That is a great concern and would counter the suggestion that we are trying to eradicate war crimes and prosecute war criminals in this country. But it's a credit to the Australian government that it finally did introduce these amendments in 2002 and ratified the Rome Statute to fulfil its obligations from more than 50 years prior in ratifying the Genocide Convention. We need to now take the next step and make it justiciable, make it practicable, and remove the obstacles to prosecution and make real our commitment to preventing and prosecuting genocide and the other atrocity crimes.
One of the most difficult things to prove in genocide cases is the intent to destroy the group.
Yes.
In whole or in part. In what way do you believe Australia's actions of destroying First Peoples here were intentional?
It's not an area I went into, attempted to go into in any detail because it is very technical. I do take from the Bringing Them Home report the conclusion of the authors of that report, Wilson and Dodson, that the ultimate purpose, and I'm quoting, of child removal was to control the population, to control the reproduction of First Nations people in this country. If that was the purpose of removing children, then their conclusion would suggest that it was intentional. My understanding, and there are people whose whole lives are dedicated to genocide studies, and I'm not one of them, so I would defer to them, but my understanding is that intent is not equivalent to motive, or indeed does not need even to be malicious. So if the intent was to destroy in whole or in part Aboriginal people, that does not even need to be malicious. The arguments at the time, and I apologise for the language and attitudes reflected in our submission, that I attempted to make an accurate reflection of historical attitudes that were. There are many people who argued at the time that removing children was necessary for their own interests. So even if we took that on face value and on good faith that was the intention, if the intention was also to prevent reproduction of First Nations people and to destroy them in other ways as a group, that is, if I may... What was it? It's denies the group the means of self-perpetuation, not only in terms of sexual reproduction, but physical reproduction of the group members as a group, as distinct from the broader society. And by taking children away from their parents and their families, you do exactly that. And by placing them in institutions or non-Aboriginal families, you do exactly that. Remove the potential, the possibility of that culture perpetuating itself to the next generation and preventing group members from continuing the features that define that group. That is language, culture, history, tradition, law, being prevented physically and practically from passing those on is a way of destroying that group. And thus there are multiple complex meanings of genocide. It's not simply the popular notion of killing people, although of course massacres did occur extensively in this country, and I've not sought to document that or discuss that in this submission. Have I answered your question? I can't recall.
Yes, you have. Thank you, Chair. Have I got time for one more?
Yes, you do, Senator Thorpe.
Thank you. The Rome Statute is based on the principle of complementary, meaning that the ICC only has the jurisdiction to try a person if the state or states that have the right to try, like Australia, are unable or unwilling to genuinely investigate and prosecute. Given the AG's fiat, would you agree that it is effectively impossible to investigate and prosecute atrocity crimes in this country?
Of course, technically it is possible. In practice, it is proven extremely difficult, and I think an argument could be made that Australia is unwilling to prosecute, and that power resides exclusively with one person, namely the Attorney-General. So, yes, Australia has, I would say there's an arguable case to be made that Australia has been unwilling but is not unable to prosecute atrocity crimes in Australia. Having said that, I don't think the burden should be on victims and survivors and their families to exhaust all domestic remedies and refer their concerns to the ICC. Added to that, the ICC has an enormous burden of matters before it, and in its 22 years of existence has brought fewer than 50 cases. So there is a long queue, as is common with other treaty bodies and means of redress at the UN. It would not be desirable or practicable for Australians or people concerned about war criminals and other kinds of atrocity criminals living in Australia having to go to the ICC, though of course they are entitled to do so.
Thank you very much. Great answers. Thanks for attending.
Thank you, Senator.
Thanks, Senator Thorpe. Senator Scarr, do you have a question?
Yes, thank you. Thank you, Chair. Thank you very much, Dr. Ball, for coming along and coming along in person too. That assists us. So thank you for taking the time to do that. I was looking at the Bringing Them Home report whilst you were giving evidence to track down the recommendation you referred to.
Yep.
And recommendation 10 states, quote, that the Commonwealth legislate to implement the Genocide Convention with full domestic effect, end quote. So that's the recommendation you're referring to, yes?
That's correct, yes.
As I read the commentary leading into that recommendation, this issue of retroactivity or application of the law prior to legislation to implement the Genocide Convention being passed wasn't dealt with in terms of, there doesn't seem to be any commentary I could find, and you may be able to assist, that dealt with this issue of the time period between 12 January 1951, when the Genocide Convention came into effect, which Australia was a signatory of,
yes,
and 2002, when the Howard government introduced the legislation. It just, on my reading of the recommendation in the Bringing Them Home report, it's simply saying the Commonwealth should legislate to implement the Genocide Convention with full domestic effect. Is that correct? Was there any discussion, and feel free to take it on notice, around retroactivity and this period between 51 and 2002?
I would have to take that on notice. I did not attend the inquiry, but I could. I'm not aware of any discussion, but I certainly could take that on notice and come back to you.
If you could, that would be helpful. A number of and I'm interested in the comments you made about Australia's willingness or otherwise in relation to pursuing prosecution of the matters which are covered by the Rome Statute, the Genocide Convention. We've received submissions which refer to cases involving foreign leaders, and I expand that to include, it seems that the customary law, I'm not sure what term to use here, says there are privileges which are held by foreign leaders, potentially foreign affairs ministers, and potentially other limited leadership roles in foreign countries, which give them immunity from prosecution. And I could find two cases in the submissions which fall into that category, and therefore there was no ability, the argument is, to bring prosecutions against those individuals. Are there any other cases you're aware of where prosecutions have been attempted to be brought but were frustrated because of the fiat in practice?
Against themselves?
No, well, cases where someone has attempted, where someone has attempted to initiate proceedings, potentially even as a private prosecution, and they've been frustrated or prevented from doing so because the attorney has exercised the attorney's fiat or right to say, well, no, you can't do that independently and I'm not going to do it.
In other jurisdictions other than Australia?
Well, either.
I think Uncle Robbie Thorpe has been greatly frustrated in his attempts over 27 years. I couldn't comment on other countries. We focus exclusively on Australia, though that immunity of serving heads of state has the unintended consequence of people, of course, holding on to power so that they can avoid prosecution, which is unintended, but I couldn't answer your question, I'm sorry.
Point well made. So Uncle Robbie's case in the High Court was in, I think you're here for the previous testimony, was in 1997. So that predated the adoption of the Convention as domestic law in Australia in 2002, in accordance with the Bringing Them Home report. Are you aware of any other claims that have been made in Australia of the nature, and feel free to take it on notice, in the nature of Uncle Robbie's claim?
I'm not best placed to answer that because Remedy Australia, we focus on claims taken to the human rights treaty bodies at the United Nations. I'm not aware of any atrocity crimes that have been attempted to be resolved in that respect, that is going to the treaty bodies.
And when you say treaty, sorry to interrupt, when you say treaty body, you mean that includes the International Criminal Court?
No. The human rights treaties that Australia has ratified each has a other than the Genocide Convention, but the International Covenant on Civil and Political Rights, the Convention against Discrimination Against Women and so forth, each have a body of experts that is called a treaty body or a treaty committee that is the highest global authority on interpreting the meaning of that convention, and individuals and groups have the power to, having exhausted domestic remedies, can go to those treaty bodies for a quasi-judicial determination of their claim of rights violations under those treaties. So that's what we focus on as an organisation, and improving domestic remedies for human rights violations in Australia, and we focus only on Australia. So I'm not in a position to comment on prosecutions in other countries.
Right, okay. All right.
I'm afraid.
Are you aware of any such claims being made to any of those treaty bodies?
Oh, yes. Of atrocity crimes, no. Not to date.
Okay.
There may be some on foot that we're not aware of.
That you're not aware of?
Yeah.
Okay. Okay. There is I quickly read the Treaty of Rome on the plane down here, so I'm not pretending to be an expert, far from it. But actually, I was trying to limit my expertise by that comment, but maybe unsuccessfully. But there does appear to be some sort of association of members under that treaty where matters can be referred to the association of members if a state party is unwilling to act in a certain way. Does that fall within the ambit of treaty organisations that you're referring to?
No, it doesn't.
Okay. All right. And you do recognise, and you did refer to the fact that the Office of the Special Investigator has been established within Australia to look at allegations made in relation to events that occurred overseas. Does that give you some degree of, I'm not sure comfort's the right word, but does it put the current status of the exercise of these fiats in some sort of perspective? That is an example where after a process there was the actual establishment of an Office of Special Investigator with appropriate resources to look into those allegations?
It does. I mean, the only war crimes that could be tried prior to the amendment in 2002 were crimes committed during World War II in Europe.
Yeah.
And so that Special Investigations Unit was focused on that. I couldn't give you any great detail on it. I'm not an expert on that, but it was disbanded in 1992.
Oh, sorry, I was referring to the unit that's been established in relation to accusations in relation to activities in Afghanistan. Just recently.
I beg your pardon. I'm sorry. No, I couldn't comment. Sorry.
Okay. All right, thank you very much, and thanks for appearing today.
Thank you very much, Senator Shoebridge. Do you have any questions?
I do. Thanks, Dr. Ball, for your appearance today, and thanks to Remedy Australia and the broad team for the work they do. Much of your submission deals with genocide that occurred within Australia, and you particularly focus on the stolen generation as an act of genocide. And much of the opposition to these amendments from the department comes from their concerns about wanting to ensure Australia's international relations and national security is not prejudiced, and retaining the Attorney-General's veto power for those reasons. They don't really engage, though, do they, with genocide that occurs on this continent? Those kind of rationales from the Attorney-General's department.
About our international relations? Well,
unless you take the argument of an independent sovereignty of First Nations peoples, but putting that to one side.
Fair point. Yeah. I mean, the first thing that comes to mind is that Uncle Robbie is wanting to bring charges against King Charles. So to the extent that he's not just the King of Australia, it is an international relations matter.
But up to the extent that government officials and decision makers and political leaders intentionally put in place a policy of genocide through the removal of First Nations children, and that occurred within Australia, it's difficult to see an argument that says, well, you can't allow that to proceed because it may impact our international relations.
I concur. That is hard to make that argument. Before Federation of Australia, when we were a colony, that would implicate the colonial power of Britain.
But the bulk of those offenders from pre-Federation have deceased, I think we could comfortably say.
And it's prior to 1951 anyway. So since 1951, it is a domestic matter, yes.
Yeah. So, you know, I don't know if you've had the opportunity of reading the submission from the department, but its principal opposition to these law changes are that, well, the Attorney-General needs to assess national security and international relations and therefore needs to have a veto. I don't see how that, you know, in any way engages with potential or actual, and, you know, I believe they're actual genocide that occurred within Australia.
No, there is no discussion in the Genocide Convention of whether those are grounds for derogating from the obligations under the Convention to prosecute and prevent genocide.
In me asking this question, I don't assume that I think there's legitimacy in having a political veto for other acts of genocide. But has Remedy Australia considered whether or not that there might be a separate regime for prosecutions within Australia under the Commonwealth law where the genocide occurred within Australia? To have that go down just a far more standard prosecutorial track with the DPP, because it doesn't engage any of those international considerations.
That's not something that I've considered. I accept that that could be an effective workaround politically, but the Genocide Convention and the modern human rights movement stems from the genocide that occurred in the Second World War. The Genocide Convention was adopted and opened for signature the day before the Universal Declaration of Human Rights was adopted at the United Nations, precisely because these crimes that so outrage the conscience of humanity are considered paramount, and their prevention and prosecution is paramount.
I am going to come to acts of genocide that occur outside the Commonwealth of Australia, and we can deal with that separately. But I suppose I'm asking whether or not you might want to take on notice a review of the Attorney-General's submission and what, if any, impact that would have on prosecutions for alleged genocide that occurred within the Commonwealth of Australia.
Yeah. I'd be happy to take that on notice. Thank you, Senator.
And I'm not suggesting I have a view that there should be a twin-track process, given the international law says genocide is a crime wherever it occurs that should be both prevented and prosecuted. But I'd be interested in your thoughts on it, and particularly given the depth of experience within Remedy Australia. Do you accept that where a genocide occurred outside of Australia, or is alleged to have occurred outside of Australia, do you accept the legitimacy of the government's argument that there are international relations and national security concerns that should be a sort of wash over a decision to prosecute or not?
Of course, those considerations are a fact and they exist, but should they trump a prosecution of the most egregious crimes that we define as humans? No.
You see it it's a difficult argument, really, isn't it, for the Commonwealth to make, and they make it in the submission from the department. They say, well, even if there is a genocide, and they accept that there's a plausible case for a genocide having occurred, and they can potentially identify a perpetrator or perpetrators, that it may be in Australia's national interest not to prosecute for genocide. It's hard to see, even if you take a medium term of history, how our national interest can benefit from not holding perpetrators of genocide to account. But, you know, is that an argument you see in other jurisdictions?
I couldn't comment on other jurisdictions. I've no doubt that that is an argument and a view that people would take.
We'll just let this genocide slide in the interest of the interest of our national security.
This is always going to be a factor, and that's why we need independent prosecutorial units of investigation, why we need the International Criminal Court, why we need impartial means and processes and access to justice.
If we assume that genocide is in that class of most heinous crimes, permitting considerations like international relations and national security to prevent prosecutions, it's almost weaving a conflict of interest rather than a valid consideration, an active conflict of interest into the decision-making matrix, isn't it?
Yes.
Has Remedy Australia considered what, if the Parliament was to put in place statutory criteria for determining whether or not to commence a prosecution, and perhaps gave that to, say, the ODPP, the Office of the Director of Public Prosecutions, have you considered what relevant criteria might inform that decision?
That is not something we are able to comment on, but I know that you have received submissions on that.
Yeah. But just from your perspective, looking at the last 22 years, when we've had, at least on the statute book, laws that permit genocide to be prosecuted, it's hard to see them as effective when we know we've had people living in this country where there are very credible allegations of genocide against them from conflicts in the Balkans, when we've had no accountability for the stolen generations, and when obviously we see in current circumstances no engagement when we see conflicts such as that in Gaza and potentially other conflicts such as Sudan and Myanmar and potentially Ukraine. With all of that, those apparent crimes having been committed across the globe and zero accountability, it's hard to see the laws as working.
I would agree. An improvement would be to locate the decision-making or the gatekeeping with the Director of Public Prosecutions and to be forever vigilant about our democratic institutions and their independence and separation of powers to ensure that that is an independent decision process.
My time's about to run out. The Chair will remind me. It's about more than just changing the laws, isn't it? It's also about resourcing the investigation of these crimes.
Yes.
Do you support a standalone war crimes unit or an identified and well-resourced unit within the AFP, say, to build the specialised knowledge and to treat this like the serious crime it is?
Whether that is the best location, it's not something we have considered, but we would certainly want to see greater resourcing of independent means of prosecution, yes.
Right.
Thanks very much. That's all the time we have. Unfortunately, we have other witnesses waiting, but we thank you for your time today and for your really thorough submission. Thank you very much.
My pleasure, thank you.
I think our next witnesses are joining us via video conference. So I now welcome the Islamic Council of Victoria and the Australian Palestine Advocacy Network. Thank you for joining us today. Thanks for taking time to speak with the committee. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. Please let us know if you have any questions about that. Witnesses are reminded that if they give evidence that reflects adversely on another party, the committee is generally required to give that party reasonable access to evidence and to an opportunity to respond. For the Hansard record, can I ask you please to state your full name and the capacity in which you appear today? We'll start with the Islamic Council of Victoria.
So my name is Adil Salman. I'm the President of the Islamic Council of Victoria.
Thank you for joining us today. Any of you joined by colleagues? Or, nope.
Yes.
I'm Bridget Mackenzie-McCarg. I'm the Policy and Advocacy Officer at the Islamic Council of Victoria.
Thank you.
I'm Zahra Wahid. I'm the General Manager here at the Islamic Council of Victoria.
Thank you very much. And the Australian Palestine Advocacy Network. Welcome.
Thank you. My name is Nasser Mashni. I'm the President of the Australia Palestine Advocacy Network.
Thank you very much for joining us today. Would either of you like to make a brief opening statement before we go to questions?
We're happy to start with a very brief opening statement.
Thanks so much.
Look, in short and in summary, we support the Criminal Code Amendment, Genocide, Crimes Against Humanity and War Crimes Bill 2024 in its entirety. And we commend the originators of this bill, and we do hope that it is indeed made law here in Australia. It's time for Australia's actions and our deeds to match our platitudes and the words and some of the promises that we've given to the international community over decades, going all the way back to when we signed the Convention in 1949. And even when we did make an attempt to uphold our international law obligations in 2002, we did it piecemeal, and it did not solve the problem, and it did not allow for justice to be sought by those who were the victims of these mass atrocity crimes. International law requires, and these international treaties like the Genocide Convention, I'll use the shortened version of it, requires that all states actually implement these laws. For them to be effective, all states need to be on the same page. And when we have some states that are not holding up their end of the bargain, then that provides an escape for the perpetrators of these crimes to seek refuge and to act with impunity. And so it's doubly imperative for Australia to not only fulfil the obligations that we committed to voluntarily decades ago, but we also fulfil our role in as a responsible international citizen by carrying our fair share and fulfilling our responsibilities as a member state. So I think in general, as I said, we support the bill. We've got some specific recommendations. I'm happy to run through those now, or we can take them in questions.
We are going to give our other witness an opportunity to give a brief opening statement.
Thank you. And I'd also like to thank you for the opportunity to be here. And I understand that I'm here in a context of a genocide that's ongoing on this continent, a genocide that hasn't stopped and continues, and that genocide continues in Palestine. I'd also like to commend the motion, as Senator Thorpe has given you, for adoption, and I'd like to speak about myself and our organisation. I am the son of a Palestinian refugee. I am the son of someone ethnically cleansed from their ancestral homes. I am the son of someone who suffered a genocide that has never been accounted for, nor anyone held responsible to. I was born in this great country and afforded an opportunity that so many of my people are not afforded. I am the current and first Australian Palestinian president of the peak representative body of people who are advocating for and seeking justice for the Palestinian people, the Australia Palestine Advocacy Network. I'll be speaking to you today with respect to the concerns of our community, the Australian Palestinian community, but also of so many of our allies and supporters who can see what is happening, can see a digital genocide and can see a significant disconnect between the actions and words of our country and its obligations and its commitments. Australia is globally recognised as a country that believes in rules, in democracy, in a rules-based order. We're a long-standing signatory to the Rome Statute. We've ratified every international convention on humanitarian law, etc., that I can imagine. That said, we are witness to a hypocrisy, a duplicity with respect to the country's actions when it comes to Palestine and how it might apply to any other country, and most starkly, in fact, with regards to the Ukraine. It's disturbing that the application of international law, the application of any action against genocide is so politicised. It's baked into every element of our domestic political language. In 2009, the Australians for Palestine, a precursor of APAN, Australians for Palestine, made a submission under the Genocide Convention as the former Prime Minister of Israel, Ehud Olmert, was visiting Australia. We made an application for the Federal Police to issue an arrest warrant for him. The response came back to us after he had left. The Australian Centre for International Justice, has made a submission to this committee. Disappointed that they haven't been afforded the opportunity to present, but there are many other cases there, with respect to Aung San Suu Kyi on behalf of the Rohingya people and some others that have fallen by the wayside. The amendment in 2002 that gave the Attorney General this fiat is, and ultimately that this can't be contested, that his decision can't be contested, rules out the opportunity for natural justice to be occurred as it sits with just one person. Today, as a Palestinian Australian, we are at day 297 of a digital genocide that the entire world is watching. 295 days since the Israeli Defense Minister Yoav Gallant said to the world unashamedly, we are imposing a total siege on Gaza, no electricity, no food, no water, everything is closed. We are fighting human animals. Australia failed to take decisive action then, as it is obliged to. On the 2nd of November 2023, 271 days ago, the UN said, we remain convinced that Palestinian people are at grave risk of genocide. On the 26th of January, 186 days, the International Court of Justice
I'm sorry, Mr. Machini, your audio and video has just cut out temporarily. We'll see if we can get you back. We can always accept your opening statement in writing as well, so that it's part of incorporated into the committee documents. We'll see if we can get Nasir back. In the meantime,
I'm back.
Oh, we do. We have you back. Sorry, I was just going to say we could take the rest of your statement in writing, but if we've got you and you're ready to finish, and then we'll hand over to questions from senators. So over to you.
Very quickly.
Yes.
Can I just finish this point?
Of course. Go for it.
No, thank you so much. And so the 26th of January, the 26th of March, UN Special Rapporteur Francesca Albanese said she had reasonable grounds to believe that the threshold had been crossed for the commission of genocide. Australia's former Human Rights Commissioner, Chris Sidoti, on the 19th of June said he had 7,000 pieces of verifiable evidence that crimes against humanity and war crimes have been committed. Nothing has been done. If there has never been a more pressing time for the Australia's obligations with respect to a genocide and our actions to sit outside of the Attorney General's fiat, I don't know if there ever will be a more pressing time.
Thank you very much for those opening statements. I'm going to hand the call to Senator Thorpe to start questions. Thank you, Senator Thorpe. You have the call.
Thank you, Chair, and thank you all for appearing today, given the ongoing genocide that your people and my people face. Mr. Mashney, you are here today representing APAN during a time when your people go through what can only be described as the worst of all atrocities, a genocide. My heart and thoughts are with you all, and Palestinians, and I truly hope that you get to live in peace and freedom soon. While your people are being killed in this ongoing genocide, we are talking about the legal means people have to hold to account those that perpetrate it. In light of the AG's fiat, do you think that it is a real possibility seeking justice for crimes against humanity in this country, whether committed here or elsewhere? That's my first question. And second to that, do you think that in the current situation, it would have been easier to pursue accountability and potentially action to punish, prevent or stop the genocide in Gaza if there was no AG's fiat?
Thank you, Senator. I appreciate that question. There is absolutely no question in my mind. There is no question in my mind that and it's evidenced absolutely starkly by Australia's commitment to international law when it comes to, quote unquote, almost everybody that isn't Palestinian. It might be the 568 autonomous sanctions imposed on Syria, the 700 odd imposed on Iran, the more than 1,300 that are imposed on Russia. Australia has yet to impose a Magnitsky-style sanction on an Israeli official. Has yet to. We've got a defence minister of a nuclear-armed state, turned off the gas, electricity, water and food to 2.4 million people almost 10 months ago. Almost 10 months ago. And one of the only decisions Australia has taken was to defund UNRWA, the United Nations body responsible for Palestinian refugees in Gaza. It is beyond imagining that there wouldn't be an easier way for us to hold Israel to account for its genocidal actions. And we should say that these genocidal actions that we are seeing today in the past almost 10 months are because of 76 years of countries like Australia signing on to conventions, but turning a blind eye to Israel's rampant and flagrant ignoring of international law, etc. And as we saw only 2 weeks ago with the International Court of Justice ruling unequivocally that the West Bank, East Jerusalem and Gaza are occupied territories, that they should immediately be vacated, those settlers should be vacated, but also that they were in violation of the Convention Against the Elimination of Racial Discrimination and therefore an apartheid state. That to date, Australia, speaks a big game diplomatically about international law and rules-based order, sits behind this fiat and protects itself and applies those sanctions, applies layers of diplomatic pressure when and where it wants, and entirely the decision is made politically, not based on humanity. And when we're talking about the crime of all crimes, genocide, that needs to be taken away from some sort of political decision-making matrix.
Thank you. And to follow up from that question, for APAN and perhaps that of the wider Palestinian community, what has been the experience trying to urge this government, to take action to end the ongoing genocide?
I would say that our efforts have fallen all but on deaf ears. We are now fast approaching, this weekend will be 300 days. 300 days since that Israeli defence minister cut off food, gas, electricity and water. 300 days since a population was purposefully starved. 300 days of women giving birth via cesareans without anaesthetic, children having limbs amputated by their parents with kitchen utensils, children after operations being given a Panadol for pain relief, measures that doctors have reported back to us that they haven't ever encountered, doctors who have been to war and famine-ravaged and natural disasters all over the world, seeing and reporting amongst the most horrific of outcomes. That, as Australians with Palestinian ancestry, for us to see our government choose words so very carefully. Israel has got a right to defend itself, but how it defends itself matters. To be political in its language and not to come out and speak to our humanity as if we are equal has been heartbreaking, soul-destroying, and has created a fracture in our social cohesion that I fear may never be restored. It is beyond and past time for our government to depoliticise its language, to depoliticise its decision-making framework so that we are treated as equal. There should be 1,300 sanctions, as there are against Russia, against Israelis, or at least 703, like there is against the Iranians, or 506, like there is against Syria, on Israel for not complying with international law, not just since 300 days ago, but since 1948. The threat to democracy and social cohesion and the language our government is using with regards to our community and how they protest is particularly hurtful. And the way our protests are being conflated as some sort of anti-Semitic movement, for Palestinian justice, for discrimination, for humanity, is an anti-racist, anti-colonial struggle. Anti-racist, anti-colonial. We do not accept the demonisation of our movement. We do not accept that the fight for justice with Palestinians is anti-Semitic in any sense. And the continuation of that language is to belittle, demonise and degrade us. And we can't accept it.
Thank you. I see a government senator shaking their head when you mention the government's response to supporting Palestinians right now. So just so that we can be clear, if we've got a Labor government senator shaking their head not agreeing, what were the key considerations from government not to support Palestine? Like, what is their excuse and why, with all these deliberations, with the advocacy from APAN and other groups, what is the government's excuse?
Senator, I won't relay details of private conversations, but I get a general sense, and based on the communications, where there's been a change in the past couple of weeks. We did receive finally some money for Palestinian-led organisations during the week from from former Immigration Minister Andrew Giles. We did see some sanctioning of some settlers from our Foreign Minister. We did see an Israeli entity also be sanctioned. We have seen our Foreign Minister condemn a couple of weeks ago a strike on a Palestinian school that resulted in the death of 30 children. What I would say is that all sits in a context where Palestinian Australians have asked for and spoken for the government to be robust in its language about Australian citizens serving in the Israeli occupation forces, to make it very clear that they will be held accountable for crimes against humanity, that they should be issuing travel warnings to those Australians that are travelling, that we should have a register of those Australians who are fighting for the Israeli occupation forces and anything they might be doing. There is a disconnect between the consular support that was afforded Australian Israelis and how quickly they were repatriated to Australia and how they were funded, and the outcome for Australian Palestinians, whether that was from the illegally occupied West Bank or from Gaza. There are still Australians in Gaza trapped. We've seen a breakdown in the number of visas issued, how they're issued, a cancellation of visas en route. We've had any number of issues where there have been a lesser response to Palestinians than have been afforded to other peoples, and in particular in this instance, Australian Israelis or the Jewish community here. The response we've received from the government has been, but we've called for a ceasefire. You know, Australia signed with Canada and New Zealand and issued a statement in support of. Now, I would say that if you called for a ceasefire 2 months after this latest flare-up of the 76 years of genocide, that if you called for a ceasefire 2 months after that and 300 days later no ceasefire has happened, we're beyond calling. We need to be demanding. And what does demanding look like? Now, we are demanding of Russia. We are demanding of Iran. We are demanding of North Korea and Syria. Why aren't we demanding of Israel? And demanding means not just a call for ceasefire and offering of aid and a reinstatement of UNRWA funding. A demand for a ceasefire is diplomatic. It is expelling an ambassador. It is ending any two-way military trade, whether it's componentry or military. It is recalling our ambassador. It is imposing sanctions on any trade. We should not be normalising any country that is guilty of committing a genocide. A genocide is the crime of all crimes, and every international human rights convention that came out of World War II was to make sure this does not happen. And we have obligations, and we are not fulfilling them.
Senator Thorpe, I need to share the call, and I thought this might be a helpful time to remind witnesses and to senators there is definitely absolutely a way to link these very important issues to the bill that is in front of us that we're inquiring into, and I just direct you to do that in your answers so that we can use the information that you're giving us today in relation to our inquiry. Senator Thorpe, do you have another question?
Sorry, Chair, can you clarify that? Is there something out of line in terms of the terms of reference? Is there some way we should explain genocide and what's going on right now? Can you clarify, please?
Senator Thorpe, this is not an opportunity for you and I to have a debate. What I'm asking is that your question.
I'm asking for the clarity.
Yep, and I have given you that clarity. I've asked very simply for questions to be relevant to the bill.
I think it is relevant. I think it is. We're being very relevant, and I did have some questions for ICB. So, if you could come back to me, that I'd appreciate it. Thank you,
Senator Thorpe. You still have the call if you have another question, and then I'm going to share the call.
Okay, and if I'm not being relevant, I'd like you to explain why I'm not being relevant. Thank you. So, ICB, thank you for attending. You were stating that you are concerned and horrified by the numerous mass atrocities being committed internationally, often with seeming impunity, including what is happening in Gaza. What do you think has been Australia's role in allowing this to happen?
Well, I think our role has been very weak, and you just have to look at the record. I'll even use the example of the Rwanda genocide. There are people here in Australia that are alleged to have been involved in one of the most horrific mass atrocity crimes in certainly since World War II. And Australia has not been able to take any action to actually bring justice to the people of Rwanda who suffered, as I said, the most horrific of crimes. So that's just one example. I mean, and you look at Australia's history ever since our founding as a modern state and settlement that preceded that. I mean, Australia still has not reckoned with its past. Australia needs to reckon with its past, and maybe it's because we are unable to reckon with our past that we cannot reckon with our obligations, current obligations, and our future obligations. Maybe the two are connected, and maybe that's what's holding Australia back. So if we were to take the bold, courageous step of reckoning with our past, then maybe everything else will flow, and we will then start to uphold our obligations under international law. Genocides have happened since World War II. We said after World War II, never again. The Genocide Convention came in and it was, layered with platitudes and great intentions and noble intentions, never again. But since World War II, we have experienced horrific genocides around the world, in Africa, in Asia. What happened in Cambodia? What's happening now, currently, obviously, in Myanmar? Certainly what's happening in the occupied territories of Palestine. All of these should not happen. There is absolutely no excuse for the world to allow these mass atrocity crimes to happen. We have the means to prevent them. The genocide that happened, or the mass atrocity crime that happened in Bosnia in the mid-90s, the world stood by, the UN stood by and allowed it to happen. They were on the ground. They saw what was happening. They knew there was going to be a mass slaughter that took place of Bosnians, and they still allowed it to happen. So the international community has failed miserably since World War II. I'm not going to talk about what happened before World War II, but certainly since World War II. But we have the means. We have the means now. We have the resources. And Australia should be a leader. We are a wealthy nation. We value human rights, at least that's what we say we do. And we have a stable political system that allows us then to focus on what happens outside of our borders and not be preoccupied by internal division and civil war within our borders. We don't experience the issues that other states are suffering in terms of turmoil, disasters, civil conflict. Australia is stable. We have the wealth, we have the means, we have the stability to actually be a leader in upholding international law. And it is past time that we did so.
Thank you. And again, ICV, you state your support for my bill,
Senator,
and that it is
I do need to share the call. If there's some time at the end, I can come back to you. Or you can put those questions on notice, but I do need to share.
I'd like to come back to me. Thanks,
Senator
Chair.
Shoebridge, do you have questions?
I do, Chair.
Senator Shoebridge, you have the call. We'll try to come back to you, Senator Thorpe, because I don't think others have questions.
Thanks to all the witnesses for coming and for the work you do, not just in this inquiry, but with your communities throughout the year as well. I think each of your organisations say very clearly that you view the existence of the Attorney General's consent/veto power as an inappropriate political interference in what should be a legal determination. And I think I understand you both to be saying that. Do you think that the decision on a legal matter should therefore be handed over to the Director of Public Prosecutions who has well-established independent procedures for determining legal liability? I might go to you first, Dr. Solomon, and then you, Mr. Mashnick.
I'm not, by the way, thank you, Senator. I'm not a doctor.
No, sorry, Mr. Solomon. There's lots of doctors and professors coming today. Yep.
I've been called many things, including sheikhs and imam, but I'm neither of those either. Anyway, yes, I think it should sit with the Office of Public Prosecutions. I think that's really the only sensible approach. It should definitely not reside or sit with an elected official, not the Attorney General or any other elected official. But preceding that, and it's really important to make it successful, is that there must be an independent investigative unit, and we need to resource that investigative unit. And I don't think that should be subject to any political interference, and that should be completely independent and that should be the means by which the Office of Public Prosecutions or the Director of Public Prosecutions is armed with the information they need to bring charges. And I think the two must go together.
Yeah, thanks. I was going to say Professor Mashney next.
Thank you, Senator. I'll take Professor. I'd like to be a professor. I too agree with what the former professor said, Dr. Alderson. Look, we absolutely need to take it out of a political space, and the fact that our Attorney General has a fiat over anything enables for these decisions to be absolutely political and not based in humanity and reality. What we need to be doing is respecting, not just saying we respect international law, but showing it. We need to be showing it. Actual actions, and removing the Attorney General's fiat is just one of those. And it definitely needs to be independent. And I'd commend the Australian Centre for International Justice's recommendations, and one of their recommendations is the establishment of a permanent specialised international crimes unit that is removed from the political process.
Yeah, and do I understand APAN also endorses that as a necessary prerequisite for us enforcing laws against genocide, to have that permanent, well-resourced investigative body in place?
We would.
Yep.
We would. The Attorney General is an elected member of Parliament. He sits in Cabinet. He participates in parliamentary debates. He's a member of a party that has a particular ideology. Yep. Genocide needs to be sitting outside of that space.
Yeah. Well, there are two aspects to this, aren't there? One is the decision-making aspect, the kind of veto power that the law currently gives the attorney. And I understand you say that's inappropriate political interference in a legal process. The second point, though, is ensuring that there are the resources within the executive somewhere, and hopefully an independent part of the executive, to actually investigate war crimes, whether that's war crimes in the conflict in Gaza, war crimes in the conflict in Ukraine, war crimes in Srebrenica, war crimes in Rwanda. That there is a tragic and brutal reality that we face that these things aren't going away, and that's correct. And the appropriate response, therefore, is to properly resource an ongoing war crimes unit. Do you agree?
Absolutely. And with all of those genocides you were talking about, Senator, the first and foremost is what Uncle Robbie Thorpe was talking about, the genocide here. Indeed. On this.
Mr. Solomon, the Attorney General's Department, on behalf of the government, says that in advocating to retain the role of the Attorney General, that there are appropriate considerations of international relations and national security that need to be considered that may weigh against prosecuting somebody for genocide. Do you think that they are legitimate considerations, national security and international relations, legitimate reasons why you wouldn't hold a perpetrator to account for the crime of genocide?
No, I mean, national security concerns have provided cover to governments around the world to get away with the most egregious of failures. It's political doublespeak, it's expediency. We should allow our courts to actually deal with these matters. And the Attorney General himself or herself should be taken out of the equation. Their role is not to prosecute. Their role is not to sit in judgment as to whether or not a genocide, for example, has been committed. Their role is as the chief lawmaker in the land, or the upholder of law in our legal system, is to make sure that Australia's legal system is able to fulfil our domestic and international obligations. So, no, I don't accept what the Attorney General has said.
And I'm sorry, Ms. McKenzie or Ms. Mohid, did you have anything you wanted to contribute to any of these questions that have been put so far?
Yeah, if I may just add to the ICV's response, I think even if there were hypothetically a scenario where there was a legitimate national interest or national security concern that prevented this type of prosecution, that's not something that international law and that the obligations that Australia has accepted allow for. regardless of the potential legitimacy of those concerns or those interests, Australia has, committed ourselves as a party to these conventions to enacting the laws that are necessary to prevent and punish these crimes. So that there's no exception that ought to hinge on the Attorney General's discretion or on which party is in power at the time.
There's nothing in the Genocide Convention that says a state should not prosecute genocide because it's politically inconvenient to them, or it may cause them some difficulties in their international relations. That's not a feature of the Convention Against Genocide, is it, Ms McKenzie?
No, and in fact, I would say it's the complete opposite. It's an obligation to enact whatever laws and legislation and processes are necessary to effectively prevent and punish genocide.
Yeah, and indeed, you could say that when you see our government clearly say that one of the reasons they're not prosecuting genocide, and they can elect not to prosecute a genocide, is because of international relations or national security, that's almost a statement from our government that they're not going to take preventative action, isn't it? It's a reason not to take preventative action, which is directly contrary to our international treaty obligations.
Yes, yeah. I would agree with you.
Mr. Mashney?
Absolutely, I would agree with that. I mean, what we need to be doing is moving to a space where we are fulfilling our international legal obligations, and they cannot be subordinated. Our human rights can't be subordinated. Genocide prevention, international trade relationships, economic opportunities, military partnerships, none of that can be subordinated to our responsibilities to make sure genocide doesn't happen. Yeah. That's why it has to come out of a political space and be given to an independent body properly resourced to ensure that we are fulfilling our obligations to humanity.
And it's almost as though everybody but the government can recognise the inherent conflict of interest, because if the Australian government has a policy setting that promotes or assists a genocide, and that's a policy setting that the Attorney General has participated in Cabinet, then there's such an obvious conflict of interest in permitting the Attorney General to quash a prosecution and prevent a prosecution happening. It's almost, legal term for it was re ipsa loquitur. It follows from the Attorney General's political involvement that there will be a conflict of interest at one point or another, doesn't it?
Indeed.
Yeah.
Correct.
I would say as well, sorry to interrupt, not only a conflict of interest, but a conflict or an undermining of the rule of law, in the sense that if a victim of those crimes that the government is supporting were to attempt to access justice or attempt to, pursue a perpetrator through the judicial system, I have no doubt that in a lot of these cases it would be quashed by the executive.
And in fact, in a political system where you have two political parties that sharing power between them, having that political protection either in the current government or in an opposition party, in the large opposition party, it provides almost a permanent political protection, doesn't it, from the government of the day? Because it's like, you don't prosecute me and I won't prosecute you. It's almost an unspoken political compact, isn't it?
It certainly can be read that way. There's no question. And that broader hypocrisy, that feeds into the broader hypocrisy that the community is feeling and the discontent that's, rampant throughout so many communities all over the continent.
Yeah, it's like when you look at it in that perspective, the laws that were put through in 2002 that purport to hold Australian governments, Australian decision makers to account for actual or potential genocide, including not preventing genocide, it's almost as though they wrote into it a get out of jail free card if it's politically inconvenient. That's really what this is. It's the get out of jail free card, isn't it, for Australian decision makers?
It is, unfortunately.
Yeah.
It can be read no other way.
Yeah. Okay. Thanks very much.
Thanks, Senator Shoebridge. I just have a couple of questions. I'll try to keep them as brief as possible. They're really just points of clarification, and hopefully I can hand back to Senator Thorpe before we move to our next witnesses or our break. We had some evidence this morning about, I guess, the purpose of supporting the removing of consent by the Attorney General for these types of prosecutions. Practically, how do you see that happening in the circumstances that you're referring to? Is it to enable a private prosecution to happen, or is it you are envisioning the Department of Public Prosecutions, the Director of Public Prosecutions bringing a case?
I'm happy to start. Yeah, I think it's the latter. Sorry, if it's okay, I'll start. Yeah, I think it's the latter. I think it needs to come from the Office of the Public Prosecutions. I think private prosecution, I mean, the reality is that to actually bring a private prosecution in Australia is really difficult. I mean, I don't know of too many cases where that actually happens. And our legal system is framed in a way, as opposed to other legal systems perhaps in other countries like France where you're able to do something like that. I think in Australia it all is routed through the police and the Office of Public Prosecutions. I think that's the tradition that we have here, and I think that's, given the resources required to be able to do something like this, I think it needs to come through that channel as opposed to private prosecutions.
Okay.
I would commend to the committee the Australian Centre for International Justice's recommendations, where they speak specifically 5 very clear recommendations. And firstly, for the consent of the Attorney General to be repealed, that the discretion be amended to be to an appropriate set of legislative tests, to repeal the restrictions on review, and that, in my mind, you know, that number 5, their 5th recommendation from the Australian Centre for International Justice is that Australia establish a permanent specialised international crimes unit that would afford Australians the opportunity to refer a concern to, and that concern can sit as a human concern outside of the political, economic and international relations and the interests of the sitting government, whichever government that might be. Sure. That humanity prevails over diplomatic and military and economic interest.
Understood. Thank you for clarifying that for me. If it was the case that the consent was repealed, the Commonwealth DPP would no doubt still have some guidance around when to bring prosecutions in the same way that they would deal with all criminal matters. What sort of checks and balances would you consider appropriate in that circumstance? For considering for the DPP for considering when to bring prosecutions forward?
Would it be different, Senator, to the current checks and balances? Are you envisaging there would be a separate set of checks and balances?
Well, that might be the answer to the question I'm asking. Yeah.
Okay. I'm just seeking clarification. That's all. I think we do have a system of checks and balances in our laws, in our legal systems, to ensure that there's no abuse and there's no politicisation of prosecutions, and there's a minimum evidentiary hurdle that's overcome when a case is brought by the Office of Public Prosecutions. I think our system works well generally. I don't think we need to insert any additional checks and balances unless it was shown that, for some reason our current system of checks and balances is not sufficient for crimes such as this.
Mm-mm. I'd agree with everything that Professor Adler just said, but add that there might be a need to add some special provisions because, this is not domestic law, but international humanitarian law with respect to genocide, the crime of crimes. And if you were to have a look at Australia's lack of fulfilment under that for 76 years. For 76 years, not just on the case of Palestine, but certainly genocides around the world, from Myanmar, Srebrenica and Rwanda, but also here, it's very clear. It's very clear that it needs to be taken out of a political environment and handed to an independent body that can judge, that can bring justice to those that have been denied their humanity.
Okay. Senator Thorpe, we are running over time, but if you have one quick question, we're running into our lunch break, but if you have a question, you can put it and then we'll have to finish up. Sorry.
Thank you, Chair. I have two questions. One for NASA, Mr. Mashni, sorry. You point out in your submission that the ICC and the ICJ have no independent volition or enforcement qualities of their own, and that it is therefore even more imperative for states to take preventative action to prevent genocide and other atrocity crimes from occurring. What are some steps states can take to this extent?
Yeah. So at the moment, if you wanted to look at what the Attorney General's fiat looks like, you can have a look at what the Security Council does whenever the International Court of Justice offers a ruling. That is to ignore or to veto a General Assembly a resolution asking for intervention. When it comes to Palestine, the ICJ is a toothless tiger. It is a space designed by, if you will, the system to ensure a protection exactly as exists today following 2002. That ruling that gave the Attorney General the fiat over prosecution, etc. What this would do is allow for Australia to act authoritatively, independently and humanely when a genocide is occurring. Authoritatively and humanely. And that would hold account so many other countries. Australia as a middle power could be the beacon we profess to be. And this would certainly be a way for us to be able to do that.
Thank you. And ICJ, you state you support my bill that I've put forward and that it is crucial, it's a crucial time to act. Why is it really important to act now and not further delay such reform?
Because of the what is happening around the world, Senator. I mean, and Gaza is only one example of a genocide. There are other genocides happening right now around the world. So the crimes committed by human beings against each other are not diminishing. In fact, they're escalating in their ferocity and their cruelty and their tremendous loss of life. And so the more we sit on our hands and delay this, the more innocent people will be killed, the more cultures will be eradicated, the more people will be oppressed and repressed and their basic humanity taken away from them. So it's not a question of why now, it's a question of why not now? Why not now? And given the context and what we see, and as my colleague, Professor Mashni, mentioned, the digital genocide, I mean, we see with our own eyes on our own screens what is happening in Gaza. And the world is moving. If you look at what's happening around the world, the people, humanity, they are moved. We need our political masters to move in line with that and take their responsibility seriously. And Australia should be at the forefront of that.
Can I just add one very quick thing? The sanctity of human life has to be paramount. The sanctity of every human life, however they look, identify, their religion, their colour, their creed, the sanctity of humanity has to prevail. This is an emergency that requires urgency. It's time for Australia to act.
And Bridget...
Sorry, Senator Thorpe, we are going to have to wrap up.
I just wanted to give the opportunity for Bridget to also comment.
Thanks.
Okay.
I don't necessarily have a lot to add, but something else that we outlined in our submission was that this has been delayed long enough. I mean, when these additions were added to the Criminal Code Act in 2002, they did nothing to bring justice to people who had been victims before that. They could have retroactively enforced some of these laws, but obviously they didn't. Australia has recognised that these international crimes are illegal since 1949, but very little has been done until now. So as Adil said, I guess the question is why not now?
Thank you very much.
Great.
Thanks, Chair.
Thank you.
Thank you, Senators, and thank you to all of our witnesses for giving evidence today. We thoroughly appreciate it. If you've taken any questions on notice, we'll give you a date to come back to the committee and we'll have a little bit of time to consider those answers. The committee is going to suspend for lunch and we'll return at 1:45 p.m. Thank you.
Thank you very much.
welcome via video conference Mr. Ry Atkinson, representing Amnesty International Australia. Are you there, Mr. Atkinson? I can see. Yes, fantastic.
Yes, Senator, thank you.
Thanks for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. You're reminded that if you give evidence that reflects adversely on another party, the committee is generally required to give that party reasonable access to the evidence and an opportunity to respond. For the Hansard record, can you please state your full name and the capacity in which you appear today?
Ry Atkinson, Strategic Campaigner, Amnesty International Australia.
Okay, thank you very much. Do you have an opening statement you'd like to make before we go to questions?
Yes, I do, and I've provided a copy to the Secretariat as well, so you should receive that if you haven't already.
We have it. Thank you. Over to you, Mr. Atkinson.
Okay, thank you, Chair, and all members of the committee for your time this afternoon. Amnesty International would like to acknowledge the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respects to elders past and present and extend that respect to all First Nations people present here today. Particularly in Sydney, I acknowledge the Gadigal and Gamigal people of which Amnesty's office and my home are located. For reasons outlined in Amnesty International's submission to this inquiry, the current framework of requiring consent to prosecute by the Attorney-General risks creating the perception that prosecution decisions have been made for political reasons. It is for this reason that in 2004, Amnesty warned states against including such a requirement in implementing legislation. I reiterate this now to emphasise that Amnesty understands the reasoning and in principle supports the intended effect of the current bill before this committee. That we are sitting here today discussing these matters is important, and for that I thank Senator Thorpe for initiating this debate. However, it is also true that there are very few international standards prescribing how this process should work at a domestic level. It is for this reason, paired with the political realities facing this committee and the importance of generating some positive change in this area, that Amnesty's recommendations have instead focused on changes that can increase the likelihood of this. Mainly, this concerns limiting the scope of the Attorney-General's powers over cases concerning international crimes by establishing clearer guidelines, as well as a right to appeal such a decision. In relation to the former, Amnesty included in its submission the guidelines on the role of prosecutors. And in addition to this, Amnesty would also point members of this committee to the report of the Special Rapporteur on the independence of judges and lawyers. Both come to the same conclusion. It is vital to develop clear policy guidelines as well as codes of conduct and ethics so that the scope for action is clearly defined. Another focus of Amnesty's submission was the importance of developing and implementing effective training programs for officials on the scope of crimes under international law and of the work of international criminal courts. Despite states having a duty to cooperate fully with the ICC, there have been leading figures in this parliament that have sought to do quite the opposite. The ICC is a key pillar of the international rules-based order of which Australia is a part and spends a great deal of effort promoting. It is therefore vital that states such as Australia commit themselves to a program of public education to generate support for and cooperation with international institutions such as the ICC. Lastly, I'd like to further elaborate on the final recommendation made in Amnesty's submission concerning immunity of officials, which was perhaps a little unclear. Australia is under a general obligation to cooperate with the ICC, including through the execution of the court's arrest warrants. While there has been some conjecture on this point regarding head of state immunity, I would point to key findings of the appeals chamber of the ICC, which found as much in a 2019 ruling. So while Australia's obligations to cooperate with the ICC are clear, Amnesty also included a more general recommendation that, while outside the scope of the current bill, should be of interest to this committee. That immunity of officials from prosecution for crimes under international law be eliminated, and that in keeping with customary international law, no statutes of limitations be permitted. Amnesty does not pretend that there is not a school of thought that finds that that finds that the doctrine of immunity for heads of state is an established rule of customary international law, a rule that has led countries like Australia to incorporate this into domestic legislation. Yet there is also another school of thought of which Amnesty is a strong proponent. This school of thought believes that it is a fundamental principle of international law that no official is immune with respect to crimes under international law, such as war crimes, crimes against humanity, genocide, and torture. Traditional immunities for heads of state, government officials, and even diplomats were designed to protect officials abroad from civil suit and criminal prosecutions for ordinary crimes. They were not designed to give such officials suspected of crimes under international law immunity, and they were never codified in any treaty. Now, this goes to the broader objective of this bill, and in this, I'd ask the committee which values should prevail. The interest of states in facilitating the conduct of diplomatic relations abroad by heads of state, government officials, and diplomats, or the imperative need to bring to justice those responsible for crimes against the international community and the fabric of international relations. Thank you again for the opportunity to appear today, and I'm happy to take any questions, but I will just put the caveat that I've been in this current role for just 2 weeks now, so you'll forgive me if I need to take anything on notice.
Thanks very much, Mr. Atkinson. Senator Thorpe, do you have questions?
Yes, I do. Thank you, Chair. Thank you for appearing today, Ms. Atkinson. Big fan of Amnesty as a former employee. In your submission, you state that while the International Criminal Court has been one of the 20th century's most important creations in the struggle against the worst of all crimes, the way in which states, including Australia, have implemented their obligations has undermined the effectiveness of the court. Could you please outline why this is?
Sure, thank you, Senator. Yes, countries like Australia, and it's not just limited to Australia, have put measures in place that have basically meant that the power of the court as intended has not been able to operate functionally. In part, that includes the way that Australia has implemented the Attorney General's fiat. I guess I don't want to go too much into the details of the Attorney General having those powers, generally speaking. I think in my opening statement, I guess I tried to allude to the fact that there is a diverse, there's many ways in which something like this can be implemented. But I think the issue really comes to the lack of regulations, the lack of any sort of clear guidelines around the Attorney General's decision, and really the lack of any appeal rights. And we've seen that take place in Australia over the 20 or so years that this legislation has been in place. There's been many cases which have been outlined in submissions to this inquiry, namely by the Australian Centre for International Justice submitted a great submission that detailed a few cases which have been put before the Attorney General, where the Attorney General has expressed that fear in a way that actually stopped stopped Australian courts from even analysing the legal facts, which is a detriment to international law and the development of international law. But it also stops those international crimes being prosecuted. So it's been a major hindrance. It's something that's not unique to Australia, but it's something that, as members of the Australian Parliament, you all have the power to change, and I hope that this this inquiry process can take some steps towards achieving that.
Thank you. Other countries that have similar provisions to the AG's fiat are Canada, New Zealand and the United States. Do you believe it is accidental that it is exactly settler colonies which incorporated these restrictions to the ability to prosecute genocide?
Yeah, look, I think we're talking about countries that have all, in many ways, or at least most inherited a common law doctrine from the UK. I would say the distinction with the UK process around the Attorney General is the Attorney General in the UK has far more independence from the executive branch of government than exists in Australia. But I do think I think what you're alluding to there is something that needs to be taken into consideration as well. And it's the fact that when this legislation was introduced to Parliament, there was a provision included that that crimes for genocide could not be brought forward that predated the ratification of the Rome Statute in Australia. And many would believe, and I would be included in that was expressly to stop any sort of prosecution of genocide crimes in relation to First Nations people in Australia. And that exists obviously in colonial states around the world, Australia being one of them. So I think there is certainly something to be explored down that line of questioning, and it's why we've included in our submission that statutes of limitations should not be included when we're talking about crimes against humanity, war crimes, genocide. That's Amnesty's position.
So would you agree that the AG's fiat is the kind of insurance policy for settler colonial states to not be pursued for violations of atrocity crimes themselves?
I don't think I'd necessarily put it in those words. I think, but that has been the effect of it in many ways, and that's why Amnesty would advocate for the implementation of clearer guidelines and conduct and codes of conduct for the Attorney General to follow when making those decisions, and the inclusion of an appeal process as well.
Thank you. I've got a couple more questions here. So you've expressed great concern around the AG's fiat being open to political interference, particularly given that, unlike elsewhere, the Attorney General here is not autonomous from the present-day government. What impact can this have on seeking justice in line with our international obligations?
Yeah, absolutely. And I think I alluded to that before in respect to the Attorney General being very much part of the executive branch of government in Australia. It's not unique. It's not necessarily unique, but it differs from the UK, for example. I think it comes again to the lack of guidelines, lack of ethical considerations and code of conduct around any decisions that need to be made. When it is simply up to the Attorney General to make these decisions without providing any reasoning, it is very much up to the whims of the government of the day of who is allowed to be prosecuted for these crimes. For example, and I make this point without making any sort of judgment on these two people, but I imagine the Australian government's response would be quite different to the President of the Russian Federation, Vladimir Putin, arriving in Australia, to that of the Prime Minister of Israel arriving in Australia, both who have, one who has an arrest warrant in relation to the ICC, and one who has an arrest warrant pending in relation to the ICC. So I would merely say that yes, we want to ensure that decisions that are made in respect to these matters are made on the basis of guidelines, regulations, code of conduct that are written into legislation, that are clear and are appealable as well.
Great, thank you. And has any Australian government ever considered adopting the guidelines on the role of the prosecutor developed and adopted by the UN Congress on the prevention of crime and treatment of offenders?
So the provisions that you point to, they are non-binding, but they are meant to be seen as guiding principles. I would have to take it on notice whether any Australian government has sought to implement them into domestic legislation.
Okay, thank you. I'll ask one more if that's okay, Chair.
Yeah, of course.
Thank you. You state concerns around the lack of a set of guidelines or criteria in the decision-making around atrocity cases and the lack of the right to appeal. What consequences does this have?
Yeah, I think it can lead to a miscarriage of justice, and it consequently results in lack of respect for the international rules-based order. And I think, I alluded to this in my opening statement. Australia spends a lot of time and effort in the international realm promoting an international rules-based order. And when we have systems in place domestically, that means that international rules-based order cannot be adhered to the greatest effect, then that has a domino effect. We can't be seen to be promoting a system of rules that we're also not prepared to follow.
Thank you very much. Thanks for your time.
Thanks very much, Senator Scarr. Do you have questions?
Yes, I do, Chair. Thank you, Mr Atkinson, for appearing before us. I should ask, what was your position before this one? You said you were in this position for 2 weeks.
I've been at Amnesty for a few years now. I've worked in a few different spaces, mostly relation to refugee rights in Australia.
Okay, so were you involved in preparing this submission, or was it lodged before you adopted your new position?
It was lodged. It was kind of a bit of a crossover, a bit of both, I'd say.
Okay. First question I want to ask is in relation to this United Nations Congress on the Prevention of Crime and the Treatment of Offenders, which is quoted in the submission. I haven't had a chance to have a look at that, but I do know in the footnote it says it was at the 8th United Nations Congress on the Prevention of Crime and the Treatment of Offenders, which begs the question as to whether or not it was developed in the context of considering crimes which fall within the purview of the Rome Statute, namely war crimes, genocide, etc. Do you know the answer to that? I'm happy for you to take it on notice if you'd like.
I'm happy to take it on notice in a little bit more detail. I would say that the guidelines that you're referencing there are very much seen as sort of within international law as the go-to guidelines more broadly. But I will note that there is a 2012 report from the Special Rapporteur on the independence of judges and lawyers as well that I'm happy to provide to the committee post this hearing that sort of elaborates on that as well whilst referencing that too.
Okay, thank you. I asked some questions of some of the expert academics in this area earlier today, and did you have a chance to listen to the proceedings earlier today?
No, unfortunately not. I've been busy with a couple of different things.
That's okay. You're permitted to do that. No problem.
Thank you.
You don't need my permission. But one of the areas we talked about was the factors which the attorney might need to consider in determining whether or not to exercise the discretion. And in the submission from Professor Williams, Dr. Palmer, and Dr. Hodgson, they listed a number of factors which they argued could be potentially published in terms of giving an indication. And I just wanted to quickly, I'll run through these quickly. The nature of the alleged crimes, identity and role of the alleged perpetrators, existence of any connection to Australia, including diaspora communities, whether other states have greater connection to the crimes and are willing to prosecute, where the accused is located or resides, where most of the evidence is, the likelihood of a successful prosecution, economic cost and impact on justice system, other possible venues, diplomatic impact on Australia, interests and preferences of victims, interests of the international community, risk to victims and witnesses, likely availability of immunity under international law immunity. I then cross-match those to the factors which are listed in the Attorney General's Department's submission, and that submission touches upon a number of those factors, namely consideration of international law, international relations, prosecutions that are being or might be brought in a foreign country, and other matters of public interest such as national security. So there's largely some commonality in terms of the stated considerations which should be considered. In your submission, or Amnesty's submission, it raises the concern about, in paragraph 3.2, decisions are made for political reasons. I just want to explore this concept of political reasons and what Amnesty means by that. Do you consider all of the factors I've read out to you as being bona fide factors which you would reasonably expect an attorney or a Commonwealth Director of Public Prosecutions or someone reviewing a decision would have to consider?
I think without having that extensive list in front of me and going from what you've just outlined, I think there are some issues there which I would imagine need to be considered by anyone making these decisions and should be considered, particularly around whether there is a jurisdiction that is better placed and willing to conduct these investigations and prosecutions. I think that's something that certainly should be considered. I think when going to the point of political decisions, and I think this is where Amnesty International would likely take issue, and I say this in the context of Amnesty is a human rights organisation, so we may not advocate for the same sort of considerations that I'm sure the Attorney General's Department would put forward in their submission, but taking into account for example international relations is not something that Amnesty thinks should be a consideration when it comes to the prosecution of international crimes such as war crimes, crimes against humanity and genocide. As a human rights organisation, we would argue that the preservation of justice in that instance and the seeking of justice in that instance should come before that, in the sense that it's the pursuance of that actually impacts international relations more so than any immediate political considerations.
Okay, I understand that, and offer you the opportunity to take that on notice, so you do have a chance to have a look at the submission that was made. It's submission number 9, paragraph 27, and also the Attorney General's Department submission, page 4, I think. So if I can give you an opportunity to take that on notice, given your answer, do you accept that these are decisions which involve value judgments and that reasonable people could potentially disagree in terms of what decision is ultimately made?
I think it would very much depend on what you would say would end up being that list, or what ends up being the things that need to be considered. I would argue in most things both people would disagree, that as is usually the case. But I think, what would really make the difference in this matter is that those things be published, those things be able to be accessed by the relevant people, and that those decisions be appealable as well. And whether there be disagreements over certain questions relating to that, I think they have the ability to be resolved as anything else is through the justice system.
So I can appreciate how a decision made by someone as to whether or not a purely administrative decision, which is simply dependent upon circumstances within the jurisdiction, could be considered on review, and what the appellate jurisdiction might consider in terms of whether or not the decision is appropriate or whether or not the decision should be overturned. Do you accept that in an area like this, where you're considering matters which necessarily involve potentially foreign interest considerations, national security interest considerations, that it's difficult from my perspective to envisage who actually should conduct that review and how they would come to an appropriate decision unless they had the benefit of all the information which, say, the Attorney-General has as an executive member of government, wearing the two hats of being the first law officer of the Commonwealth, but also having the access to submissions and considerations from other departments. Do you accept the concern in that regard, and if so, how would you respond to that concern?
Yeah, I mean, I would certainly accept that the Attorney-General, as part of the executive branch, may have access to information, particularly around national security concerns, that wouldn't be available to anyone assessing an appeal. But I would simply note that currently the form of review is so narrow under what's allowed now, and that any amendments to that to allow for a broader review, as put forward in a few submissions, particularly around the Administrative Decisions Judicial Review Act, is a step in the right direction. But I appreciate that there will be some information that the Attorney-General may be privy to that wouldn't be able to be made available. I can appreciate that.
Okay, my last question is in relation to this issue of head of state immunity. And again, feel free to take this on notice, but I'm interested in your response. The submission made by, I'll get this right, Dr. Cormier and Dr. Hood, which is submission 10, actually recognises in section 2 this is what they refer to, respect for head of state immunity, and they refer to that as an immunity which is extended to, and I quote, a very limited number of persons, heads of state, heads of government and foreign ministers. The rationale for giving these individuals such expansive procedural immunity in foreign domestic jurisdictions is to protect the individual concerned against any act of authority of another state which would hinder him or her in the performance of his or her duties, end quote. Is that, two questions. First, is that, from Amnesty's perspective, is that immunity currently recognised on a general basis across the world in terms of in the usual course? And so the second limb of the question is it the case that Amnesty believes that immunity on a general basis needs to be overturned and put aside with the primacy consideration given to human rights?
Yes, and I've read some of Dr. Sommier and I think it's Anna Hood's work, and respect their opinions, but I think Amnesty in this respect would disagree with their conclusions.
Sorry to interrupt. Is it that you disagree that at the moment that is a principle under customary international law, or is it that you disagree that it should be a principle under customary international law? Because there's a bit of a distinction.
Yeah, I would agree with them that many states around the world recognise it as a principle of customary international law, and the ICJ, the International Court of Justice, has stated that they agree that it is a aspect of customary international law, but there is conjecture. There are two schools of thought, and Amnesty International is on the other side of that. We would argue that, and it is true that none of the the principle of head of state immunity is not actually codified in any international treaties. It is considered a rule of customary international law based on the development of diplomatic immunities at the start of the 19th century, at a time where states were absolutely sovereign and restrained only by the rules of international law to which they gave their express consent. Even when conduct today would constitute a war crime, crime against humanity, genocide or torture. But it's certainly not the same place. The world is not the same place as it was at the beginning of that 19th century when those rules of official immunity evolved. And I think it's only in the broader context that the question of whether official immunities that are traditionally recognised as customary in conventional international law have any relevance to persons responsible for crimes that attack the very foundations of international law itself. So we would argue, Amnesty International would argue that that customary international law has evolved, that the ICJ erred in its findings in, I think, 2012, and that Australia, has extended those rules of customary international law into its domestic legislation, but the world has moved on. And the ICJ, Amnesty would say that the ICJ will eventually overturn that decision in 2012, and customary international law has evolved and will continue to evolve, and therefore Australia should do the same thing with its domestic legislation and ensure that, much like the ICC, the International Criminal Court, heads of state are not immune and should not be immune.
Okay. Well, Mr Atkinson, you've answered my questions very capably, given the short time you've been in the position. So thank you very much.
Thanks, Senator Scott. Senator Shoebridge, you have the call.
Thanks, Chair, and thanks to you, Mr Atkinson, and Amnesty for all the work that you do in this space. I don't know if you've had a chance to read the government's submission from the Attorney General's Department.
I haven't yet, Senator.
All right. They argue that it's important to retain the discretion in the Attorney General, being a member of the government, in order to allow a number of factors to be taken into consideration about whether or not, for example, the crime of genocide is prosecuted. One of those factors that they... Well, I'll just read out what they say it's on... it's usefully not page numbered, but it's... I think it's on page 5 of their submission. These factors may include considerations of international law, such as international law relating to immunities, international relations, prosecutions that have been or might be brought in a foreign country, and other matters of public interest, such as national security. Now, I might just take you through those various elements and get Amnesty's view on it. The first reason they say the attorney should retain the decision-making authority is to consider matters of international law. Now, surely considerations of international law, what the law states, could be equally done by a senior legal officer like the Office of the Director of Public Prosecutions as it could be by the Attorney General of the day. Do you agree?
I would agree with that,
yeah. There's nothing unique in the Attorney General, or even often there's absolutely no specific skill that the Attorney General has in relation to international law. They don't bring anything unique or essential, do they, through the Office of Attorney General to the consideration of international law?
I would say that you would hope whoever is in the position of Attorney General would have a unique set of skills. Well, not a unique set of skills, a set of skills, but certainly it's not a requirement, and yes, it's not unique.
It would be as much an accident as foresight that had them be a renowned international lawyer, wouldn't it?
That is correct.
Yep.
Yeah.
Then what about the concept of international relations? Do you think considerations of international relations should be a matter that Australia takes into account when it's deciding whether or not to hold a perpetrator of genocide to account?
No, Amnesty doesn't believe that should be a consideration, and in responding to the Deputy Chair's questions previously, I was trying to allude to that fact that whilst I'm sure some organisation, individuals will put forward that as a legitimate consideration. Amnesty International is a human rights organisation, and it's not something that we think should be considered in the way that is being put forward by the sounds of it, for what you're alluding to in the Attorney General Department submissions. And I just reiterate the point that I think international relations can be seen in the broader sense. When I said previously, and we'll reiterate now, that the Australian government spends a lot of time and energy advocating for an international rules-based order, of which Australia is a part of, and which Australia benefits from as well. You know, when we conduct ourselves as a country in that space, it's important that we're upholding the values that we you know, hold dear, I guess, and you know, if we're not prepared to uphold those values, then you know, the international order, international relations, in turn, can be negatively impacted.
Yeah, indeed, it would be an awkward position for Australia to state that Australia believes in international rule-based order and believes in the Genocide Convention, but thinks that they'll go soft on their allies or their friends if they commit a genocide, because it would be inconvenient to our international relations to prosecute a genocide that was committed by one of our allies or friends. That's hardly a commitment to the rules-based order, is it?
I would agree with you that, yes, you know, inconvenience to international relations should not be a criteria in which to measure whether to prosecute a case of genocide.
In actual fact, given that one of the obligations on the genocide is to not just prosecute genocides that have occurred, but to actively move to prevent a genocide, permitting concepts such as international relations into the decision-making framework works against that preventative measure, doesn't it? Because our friends, our allies may well know that Australia and other countries will not move to prevent an imminent genocide because of alliance matters or questions of international friendship. It actually works against the intent of the Genocide Convention, doesn't it?
I think including considerations such as international relations can have a negative impact, and it is true that Australia has positive obligations under the Genocide.
People criticise Australia, the United States, the United Kingdom for actually running their international legal framework through an international relations lens. And we'll often say of Australia, well, Australia, for example, has actively said that the Russian invasion of Ukraine is in breach of international law, and it clearly is, but then has taken a very different position on the genocide in Gaza and is refusing even to acknowledge it's a genocide. It's almost as though international law applies strictly against our opponents, but is applied in a different way against Australia's so-called friends.
I think it's vitally important that no states, including Australia, take a double standard when it comes to international crimes.
Could I ask you then about the other? There's two other criteria.
I've got it. Sorry, I need to share the call because we have to go to the department. If you can wrap it up really quickly, I do have a question.
Well, then I'll just deal with the last. The last one is a sort of catch-all phrase from the government. They suggest that other matters of public interest, such as national security, should decide whether or not Australia prosecutes the crime of genocide. Some might suggest that not prosecuting the crime of genocide is against our long-term national security interests. If we permit genocide to occur anywhere on the planet, that harms our long-term national security. Do you have a view about that?
I would agree with your characterisation that it is certainly a catch-all phrase, so it is hard to assess what that could possibly mean. But I would just reiterate that Australia, like all states, have a positive obligation in relation to preventing and prosecuting genocide, and it is certainly a security concern.
All right. Thanks, Ms. Wickens.
Thanks, Senator Shoebridge. I just have one quick question before we go to the next witness. In your submission at 3.10, you talk about the removing the statute of limitations or not allowing any statute of limitations to be permitted. What are you referring to in that respect? What statute of limitations are you referring to?
Casting my mind back, I'm happy to take it on notice to give a more detailed answer, but I believe it is in relation to provisions included when Australia made amendments to the Criminal Code incorporating its obligations under the Rome Statute, and I believe under those provisions that there was a provision inserted that meant that no case could be brought forward in Australia that preceded the introduction of that legislation, so 2002, which I think would place a statute of limitations on proceedings. But yeah, I'm happy to follow that up.
I think it's worth taking that on notice, just possibly to correct the record. There's no the amendments you're talking about were obviously brought into our criminal code to complement the ICC's jurisdiction, and of course the ICC didn't exist before 2022 or commenced in 2002. And there's no statute of limitation on serious criminal offences in Australia. Perhaps if you could go and give us some more specific information about what you're referring to there.
Yeah, I'm happy to take that on notice.
Okay, thank you. I think that might be all the time we have, unfortunately. Thank you very much for your time today. We might just suspend the hearing briefly while we get our next witnesses to the table. Last one. Great. Thank you. We'll now resume our hearing. Thank you. I now welcome representatives from the Attorney General's Department. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of the Department of the Commonwealth or of the state shall not be asked to give opinions on matters of policy, shall be given reasonable opportunity to refer questions asked of the officer to a superior officer or to a minister. This resolution prohibits only questions asking for opinions of matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can you each please state your full name and the capacity in which you appear today?
Stephanie Ireno, Assistant Secretary in the Office of International Law.
Thank you very much.
Good afternoon. Susan McCaig, Assistant Secretary, Criminal Law Policy Branch.
Thank you very much for being here today. Would you like to...
I might also refer to my colleague,
apologies.
Mr. Kit Malone, who is online.
Hello.
Good afternoon, and thanks for allowing me to appear remotely. My name is Christopher Malone, Director of Criminal Law Section, which is within the Criminal Law Policy Branch.
Okay, brilliant. Thank you. Does the department have an opening statement to make before we go to questions?
No,
but we've got your submission. Thank you.
A written submission. Thank you.
All right, well, we'll go straight to questions then. Senator Thorpe, you have the call.
Thank you, Chair, and thanks to the AG's department for turning up. My first question is, can you please outline the process the department goes through when someone lodges a case of an atrocity crime somewhere in Australia? What does the assessment look like on whether consent will be granted for it to be pursued?
Thank you for your question, Senator Thorpe. So where there is evidence of alleged Commonwealth criminality, then evidence should be referred to the relevant investigating authority, the Australian Federal Police. The investigation of the alleged offending is then a matter for the Australian Federal Police. Where appropriate, they will refer a brief of evidence to the Commonwealth Director of Public Prosecutions, who will make a decision then whether or not to commence a prosecution in accordance with the prosecution policy of the Commonwealth, which sets out a two-stage test. One goes to the sufficiency of the evidence, and the second is whether the prosecution is in the public interest.
Thank you. So in terms of the assessment, making the decision, we're talking about genocide in this case, particularly given it's a genocide bill.
So then for Division...
Is it the same?
No, Division 268 offences under the Code have the additional requirement that the Attorney-General would need to consent to that prosecution before it commences.
And what is that process in terms of decision-making?
So the Commonwealth Director of Public Prosecutions would refer the matter to the Attorney-General's Department with a request seeking the consent of the Attorney-General. The Attorney-General's Department would prepare a brief for the Attorney-General in relation to the request, and then the decision would be made by the Attorney-General.
Thank you. So is there any kind of transparency or accountability mechanisms around the Attorney-General's decision-making and the Department's decision-making?
So it's a decision of the Attorney-General. The Department will prepare a brief of evidence, a brief by way of advice as to the relevant considerations that the Attorney-General should take into account under the legislation. The consent to prosecute provision does not prescribe particular considerations that the Attorney-General must take into account. It's a very broad discretion, and some of the factors which can play into that discretion are outlined in our submission, have been discussed this afternoon.
Thank you. So given we talk about the most heinous crimes of humanity, How is the lack of transparency and accountability in line with our international obligations to prevent and punish the crime of genocide here and everywhere?
So, decisions in relation to matters, whether a decision is made to investigate them or not, then whether a decision is made to refer a brief of evidence for prosecution, the decision by the CDPP in accordance with the prosecution policy, whether to prosecute a matter, are not reviewable, but there are checks and balances through the integrity of those processes and the functions of those agencies.
Thank you. How many cases have been brought before the Attorney General on genocide?
Since 2002, there has been one prosecution which has been commenced for an offence under Division 268, but that is for a war crime offence which is not genocide.
So no genocide cases have been brought to the Attorney General?
That's correct.
So I just want to clarify that. So there has been no attempt from anybody in this country to prosecute the crime of genocide with the Attorney General?
So there have been no referrals from the Commonwealth Director of Public Prosecutions to the Attorney General seeking the Attorney General's consent to prosecute the crime of genocide.
Has there been any organisations or individuals seeking consent to the Attorney General for the crime of genocide? Crimes against humanity?
My colleague, Mr Malone, may be able to assist, but I understand there have been two private prosecutions which were brought forward but did not proceed.
Why didn't they proceed?
Because it's a requirement for the prosecution to be commenced in the name of the Attorney General under the consent provision, and those prosecutions didn't comply with that requirement.
So the Attorney General said no. Is that right?
Consent wasn't provided, correct.
The Attorney General did not give consent for a crime, to take on a crime of genocide in this country. Is that right?
The prosecutions were commenced in that case by individuals. They weren't referred from the Commonwealth Director of Public Prosecutions.
Thank you. So due to Australia's great international reputation, even though I'm a survivor of genocide in this country and the ongoing genocide, given the stance that Australia says that they are and how great they are of not pursuing or punishing atrocity crimes, it has now become a safe haven for perpetrators. And it's really a great legacy, I think, having the fiat in place for these perpetrators. Can you tell me what the department or what the Attorney General is doing to ensure that that is not happening, or that does not continue to happen?
So where evidence, we would encourage where there's evidence of alleged criminality for that to be referred to the relevant investigating authority. In that case, in respect of genocide, that would be the Australian Federal Police. And then it would be a matter for the Australian Federal Police to undertake the relevant investigations in the first instance.
But is there anything happening proactively from the AG's department on this issue? Or you just wait for someone to do something and respond then?
Senator, in relation to the way that the AFP operates, it's a deliberate feature of the system that investigatory bodies as well as the CDPP as a prosecution body are held at arm's length from the executive government. So they have autonomy to be able to decide what they investigate, how they do it, and what their thresholds are. There's obviously a level of ministerial oversight as to their general operations, but in relation to individual matters which they choose to investigate or alternatively not to investigate, that's ultimately a matter for them.
Thank you. Are there any actions at all that the government is taking which could lead us to believe that it is taking the obligations under the Rome Statute and the Genocide Convention serious? Because it looks like a joke. I mean, hearing all the evidence today, you know, it's a joke, it's shameful. So tell me how we're fulfilling those obligations internationally and without the bureaucratic speak, I suppose, if you can.
Look, Senator, I think one example that I can point you to that demonstrates the government's commitment to upholding international law and investigating breaches of these crimes is in relation to the work of the Office of the Special Investigator, who, as I'm sure you probably know, are responsible for addressing potential criminal matters raised in the report of the Inspector General of the Australian Defence Force's Afghanistan Inquiry Report. So the OSI, you know, working with the AFP to investigate allegations of criminal offences under Australian law arising from or related to any breaches of the laws of armed conflict by the ADF in Afghanistan. And so those investigations would be in relation to potential offences committed under Division 268 of the Code.
Okay, thank you. The intent of the 1948 Genocide Convention is to prevent genocides from occurring wherever it might be. Not a single case of genocide has been pursued in Australian courts, despite several genocides having taken place internationally since 1948, and some obviously presently occurring. The urgency to act couldn't be greater, as we currently see in the case of Gaza, with more and more people losing their lives every day, including babies. In Australia, failing to fulfil this international obligation to prevent genocide. What is the Attorney General's position on this current situation? Hello?
Yes, sorry, Senator. The current situation, are you referring to the current situation generally or in Gaza? Sorry, I'm just not sure I understood your question fully.
So is Australia failing to fulfil its international obligation to prevent genocide?
No, Senator, certainly not. Australia is extremely committed to fulfilling its obligations under the Genocide Convention. We played an active role in the negotiation of the convention. We're one of the first countries to ratify it. We have a long history of supporting efforts to promote it. Consistent with our obligations under that convention, Subdivision B of Division 268 creates a number of genocide offences to ensure domestic legislation and policies comply with international law. There are also various mechanisms in place, including review of legislation that raises international law issues, and provision of legal advices by tied legal services providers, including on the Genocide Convention, including by my office, the Office of International Law.
Could you tell me what...
I need to share the call with other senators. We might be able to come back to you at the end.
Okay.
Thanks. Yeah, thanks very much. I just have a couple of follow-up questions and I'll hand the call over. I'm having a small Qantas-related crisis, which means I'll need to keep this very brief. I just wondered whether you could elaborate on the answer you just gave to Senator Thorpe, just in regards to whether the department regards the requirement for the Attorney-General's consent to be consistent with the Rome Statute.
Yes, certainly, Senator. Look, as has already been given in evidence by a number of individuals already today, the offences in Division 268 create in Australia the equivalent offences of the Rome Statute crimes of genocide, crimes against humanity, and war crimes. Sorry, excuse me. And so incorporating those crimes in that way ensures that Australia has the legal capacity to investigate and prosecute those crimes in accordance with the principle of universal jurisdiction. The process through which that investigation, CDPP consideration, and then the Attorney-General's to consent to prosecute, the way in which that process would be carried out in Australia has already been described by Ms McKee. But certainly Australia's fully implemented the Rome Statute offences into Australian law so that we are fully equipped to prosecute any of those crimes.
I think what I was asking, there's been some submissions or evidence that having a requirement for the Attorney-General consent means that we're not consistent with the statute. That being said, there's quite a few countries that also have this consent requirement. I'm just wondering how the consent requirement particularly still allows those offences to be part of domestic prosecutions.
So the consent requirement is not an unusual requirement in the code. Insofar as across the statute books, the code more broadly, there's about 50 offences that have a consent requirement, particularly or most commonly those with an international element. And with respect to the genocide offence, then you've got category D jurisdiction, which means universal jurisdiction can apply. So any country could initiate a prosecution with respect to any offending in any other jurisdiction. There's no requirement to have a direct nexus back to Australia. So for that reason, it's appropriate that consideration be given to the views of other jurisdictions which may have a closer connection to any alleged offending, and also take into account international law considerations. And there's been some discussion this afternoon of immunities in that context. And so they would be relevant elements of the brief that would be provided to the Attorney-General in the request for him or her to consider the exercise of their consent.
And just one last question from me. Amnesty International appeared earlier. They provided submission to the committee. It suggests that the government prepare explanatory materials relating to the Rome Statute. Could you just respond to that? Do relevant parts of the Attorney-General assist the government and the broader community to understand Australians' obligations under the statute, or even just the offences under Division 268 of the Code? The submission seems to suggest there's a bit of a vacuum there, but I was curious as to what work the department does do.
We can take that on notice. I think, Senator, we share responsibility. AGD owns the domestic legislation, but DFAT leads on engagement with the ICC, so we can certainly have a look and see what's out there in terms of explanatory materials.
Thank you very much. I hand the call to Senator Scarr.
Thank you very much. I might first ask the Commonwealth Director of Public Prosecution's guidelines actually canvass circumstances where ministerial consent is required, and it refers to the fact that there can be discussion and liaison between the Commonwealth Director of Public Prosecutions and government departments in terms of assisting the Commonwealth Director of Public Prosecutions coming to a view. It recognises that in most cases the Director and the Minister of the Department will probably come to the same view, but it does recognise there could be an iterative process before the Commonwealth Director of Public Prosecutions actually refers a matter to the attorney, say, for consent. Is that, in your experience, is that how it works in practice, that before the Commonwealth Director of Public Prosecutions triggers that process of formally seeking consent, there would actually be somewhat of an iterative process where the CDPP would actually liaise with relevant government departments in circumstances where this Minister's consent issue is triggered?
I think, as I said, there are a large number of offences that actually have a consent requirement attached. And so I think it's fair to say that the circumstances can be different as to the level of prior consultation. There are established referrals, for example, in relation to crimes at sea, where the Attorney General's consent is also required, and that would normally be notified by way of a brief of evidence being referred to the Attorney General's Department attached with a cover letter seeking that the matter proceed for the Attorney General's consideration.
Sure, but the question I have...
With respect to genocide...
Sorry, the question I have is before we get to that stage, because presumably the Commonwealth Director of Public Prosecutions isn't necessarily going to know what is relevant in terms of national security, what is relevant in terms of foreign relations. They're going to be looking at it from a technical legal perspective. So to what extent do they, in discharging their obligation under their second limb to consider the public interest, will they consider those issues before formally seeking consent? Happy for you to take it on notice.
I think I'd have to take that one on notice, given that the range of...
Sure. But you understand the question?
Yes.
Yep, okay. Thank you. You mentioned, just pursuing some of the questions that Senator Thorpe raised, you mentioned 2 cases since 2002 where the consent of the attorney in relation to, I think you narrowed it to genocide, had been an issue and had been denied. There's a submission we received from the Australian Centre for International Justice, and a number of the submissions refer to different scenarios. So I've tried to write them all down to see how many I get and trying to dovetail it with your 2. The Centre for International Justice refers to these cases, so I'm interested to know if they're part of your 2. The first one is, and this is from their submission, Section 4, former Israeli Prime Minister Olmert in 2009.
I don't have the names of the matters before me, and I'd need to seek advice. Comfortable to provide sort of statistical information without providing reference to the name, so I don't have that before me. I understood that they were charges in relation to Division 268, so not necessarily...
Well, can I give you the 5 cases, and if you can tell me whether or not they're within the 2, right? And I'll have a supplementary question which I think teases out why I'm asking. So if you go to Section 4, it's probably easier if I just refer you to the section of the Australian Centre for International Justice, their submission. They list 5 cases. Some of those cases are referred to in some of the other submissions, in particular the one in relation to Sri Lanka and the one in relation to Myanmar. So if I can give you that homework, please. And the reason, the supplementary question which flows from that, we've been talking about head of state immunity So to what extent do the two cases you're referring to was consent denied on the basis of head of state immunity? Do you know? Or
my understanding is that head of state immunity was a factor.
In both of them?
Yes.
Or each of them?
Yeah.
Okay.
In each matter.
Okay, understood. Thank you. In the submission from... Have you had a chance to read any of the other submissions? I know you've got lots of time in your hands to...
I haven't read them in detail.
Okay, that's all right. I should say, if I can place on the record my appreciation that the Attorney General's Department made a submission. It's very useful from my perspective, so thank you to everyone involved. Even if they're sitting behind you, thank everyone involved in the submission. So some of our witnesses have scholarly expertise in these areas, and the submission from Professor Williams, Dr. Palmer, and Dr. Hodgson. Have you had a chance to read that submission? No? Oh, you have.
Had a summary
okay, good. I'll zero in on you then. Paragraph 27, they list a whole range of factors which potentially, from their perspective, could be listed in guidelines made publicly available for the factors which the attorney should consider in terms of exercising the discretion. And there's 12 points which are listed there, which cover all of the points listed in the Attorney General's Department submission in terms of factors to be considered. There might be one or two areas which aren't fully canvassed, but there's a lot of factors there to be considered. In responding to the submission that we should actually, the attorney's consent should be made more explicable by, or the factors to be considered should be made more explicable on the face of the statute by listing the types of factors which the attorney should consider. How would you, and I don't want to take you into policy areas, I'm really trying to hone in on the law. How do you respond to the argument that, well, we should actually list the factors that the attorney needs to consider, and then the attorney should actually issue reasons as to why the attorney decides not to grant consent where a matter's been referred to by the CDPP? Because obviously in other contexts where ministers have discretion, there are factors which are listed, which the minister needs to take into account. Usually they're inclusive, so the minister also has the broader discretion, but there are, on the face of the statute, factors which are listed. Why isn't that the case in this case?
I think collectively there is a lot of information. For example, the prosecution policy of the Commonwealth sets out considerations that the CDPP will take into account in deciding whether or not to commence prosecution. They're all also open to the Attorney General to consider.
Having said that, though, do you recognise those considerations don't really go into the realm of foreign affairs and matters such as that in a CDPP context?
Yes, certainly. I think the question of the application of international law and international immunities is also something that is well known, and the legislation itself is intentionally non-prescriptive as to the factors that can be taken into account that enables.
Yep. And what's the reason for that? Why is the legislation intentionally not prescriptive?
Because there are a range of factors which may bear on a particular matter, and so it is to give the Attorney-General the full scope to consider matters that may arise with respect to a particular request for consent. Some of those reasons are set out in the submission that the Attorney-General's Department has provided. They include matters which the Attorney-General's Department considers appropriately considered by the Attorney-General as a senior member of the Executive Government, and someone able to receive advice in relation to questions of international law, whether there are other jurisdictions having regard to universal jurisdiction that may be interested in bringing forward prosecutions, national security, international relations considerations.
Okay, yep. And just a further few questions quickly. There are other contexts in which ministers' consent needs to be obtained prior to a prosecution being initiated, and I think in the submission you refer to approximately 50 cases or instances on the Commonwealth statute books where a minister's consent is required before a prosecution is instituted. Is that correct?
That's correct.
And in any of those cases, is there a review? Is it possible to get a review of the minister's decision?
No.
Just no?
No.
Sorry, just for the record.
Yes.
Yeah.
Yes.
For the record, no.
For the record, no.
Right.
The decision to give or refuse consent is not a reviewable decision.
Okay.
Yes, outside the jurisdiction of the High Court, the original jurisdiction of the High Court. So there's a very narrow scope that is preserved, but by way, for the purpose of administrative review, judicial review, it's ordinarily not available.
And in relation to a decision made by the Commonwealth Director of Public Prosecutions, whether or not to proceed with a case, where the Director has to balance both the available evidence and the likelihood of being successful in a prosecution and also the public interest, that is also not reviewable. Is that the case?
That is also not reviewable. So, as you've identified, other decisions that are taken in preparation for commencing a prosecution, such as referral of a brief of evidence by an investigative agency and determination by the Commonwealth Director of Public Prosecutions, whether a matter should or should not proceed to prosecution, are not reviewable decisions.
Okay. And in relation to the two cases that you mentioned, if you could just take on notice where the attorney's consent was not granted, I think reasons, or to some extent reasons, were actually provided by the attorney, notwithstanding the fact that there was no statutory obligation to provide reasons. So could you just check that and see if the attorney did explain? I think certainly one case I saw referred to in the submissions, the attorney explained the head of state immunity issue, but I'd be interested to know whether or not in all of the cases since 2002 the attorney has actually given reasons, notwithstanding, or at least high-level reasons, notwithstanding the fact that the attorney is not statutorily required to give reasons. Could you just take that on notice?
I'll take that on notice.
Thank you. Thank you very much. And once again, thank you for the submission. It greatly assisted me. Thank you. I'm acting chair.
Oh, you are?
Senator Shoebridge, so it's everything's. We might extend this hearing for 8 hours or something, but
we'll
might
see
not. Senator Shoebridge.
All right. Thanks, acting chair. Thanks for your attendance today and the submission. Could I just deal with the practicalities of investigation and bringing a brief together? And is that probably more in your remit, Mr. Malone?
It's ours collectively.
Is that a yes?
Yes, either myself or Ms McKee can answer questions in relation to that.
Great. I don't know if you've had the chance to read the submission from the ACIJ, the Australian Centre for International Justice.
I've seen a summary of it and only very briefly perused it.
Well, they point out two examples where the lack of a substantive ongoing body to investigate war crimes, crimes against humanity, genocide, has created difficulties. The first is in relation to the failure to prosecute Jagat Jayasuriya, who was a senior military commander in Sri Lanka, who oversaw a significant part of the hostilities at the end of the war in Sri Lanka that ended in 2009, and is considered by many to be a notorious war criminal for that reason. He was in Australia for a number of months. A decade later, at the end of 2019, detailed briefs were provided to the Australian Federal Police by a number of bodies, including the ACIJ. And then the AFP said because of an administrative error, they never directed those briefs or concerns to anybody in the AFP to actually investigate it. Are you aware of that background?
I think we'd need to take that on notice.
Well, I suppose I was asking Mr. Maloney.
As Ms McKeague said, I'm not familiar with the specifics of that individual matter, and I think it would be difficult for us to comment on individual matters, especially those investigated or primarily dealt with by the AFP, but we're happy to take it on notice.
Well, in this case, not investigated by the AFP, even though they were put on notice with detailed dossier. That's not a matter the department looked at in any way in preparation of their submission? Is that what I'm meant to understand? You had no regard to that quite recent and notorious failure to prosecute in Australia?
Any actions that the department took in relation to that particular circumstance that you've referred to, Senator, would have to take on notice.
All right. All right. Well, if you would come back, and what, if any, notice did the department have of General Jayasuriya's presence in Australia? What, if any, notice did they have about the dossier and the concerns about war crimes? And what, if any, action was taken by the department during the 2 odd months or so he was here in Australia in relation to potential criminal liability? You'll take that on notice?
We'll take that on notice, Senator. I would note, as sort of has been canvassed, I think, in this hearing and throughout the day, is that, of course, the department has a policy and legal responsibility, but that investigative and prosecutorial responsibility ultimately falls to the AFP and the CDPP. But in relation to those specific matters that you've referred to, we'll come back on notice.
In relation to the prosecution of Oliver Schultz, a former SAS officer, was the attorney's consent sought or obtained for that?
That's an offence that has a requirement for the Attorney General to provide consent.
I know that. Was the consent sought and obtained?
My understanding is that consent has been obtained.
When was that done?
I would have to take that on notice.
Was a brief provided to the attorney?
A brief would have been provided to the Attorney General if consent was sought and obtained, but I'll need to take that on notice.
Who provided the brief, and what, if any, considerations were put before the attorney in relation to that matter?
It wouldn't be appropriate to disclose advice that's provided to the Attorney General.
Well, on how many occasions since 2002 has the attorney given consent for the prosecution of any of the offences that are the subject matter of this inquiry?
So with respect to Division 268, offences under Division 268, there's just the one prosecution.
Which is?
Which is a current prosecution.
Is that the Schultz prosecution?
That'd be the Schultz prosecution.
All right. So there's one under Division 268. And on how many occasions has consent been sought?
So consent with respect to which offence? Division 268?
Any of Division 268.
Consent has only been sought on one occasion by way of referral of a brief from the CDPP.
It is the only occasion, the Schultz occasion, where consent was granted? Because consent was clearly sought in that case and consent was granted. Is that the only occasion when the attorney's been troubled in any way under Division 268?
There has only been one referral, yes, since 2002 for offences under Division 268 from the CDPP.
Yeah. And just to be clear, that's the Schultz matter, is that right?
Yes.
Now, there have been, in the last 4 decades, multiple notorious instances of war crimes and genocide. We could look at Srebrenica, we could look at Rwanda, we could look at Myanmar, we could look at the unfolding genocide in Gaza. And despite there being criminal offences in relation to crimes such as genocide and war crimes, there's only one occasion when the system in Australia has ever put the matter before the attorney. Is that right? Only one occasion.
With respect to the domestic prosecution under 268, there has been one referral of a brief since 2002.
Now, there is, for example, in Australia, a Fijian colonel where there are serious allegations of him engaging in torture in a political context during Fijian coups. I'm assuming that hasn't come to the Attorney General. There's been no investigation and nothing brought to the Attorney General for the prosecution of the Fijian colonel who's currently in the employ of the Australian Army. That hasn't gone to the Attorney?
I think I've answered, provided information with respect to the information I have before me.
Senator Shubridge, we're at the closing time. Senator Thorpe did have a few additional questions. One more question.
Well, I've got 2 matters that I just need to
very quickly
to progress. Yeah, and it'll be finished within 8 hours. Your submission, when I say your, I mean the department's, and through that the government submission says that considerations of international relations are relevant as to whether or not genocide is prosecuted. Can you give me an example of a consideration of international relations where there was credible evidence of a genocide, there's jurisdiction for a genocide, but considerations of international relations says that the Australian government wouldn't prosecute and hold a perpetrator of genocide to account? What are you thinking of there?
It's not for me to speculate or give examples.
What's the nature of the concern, apart from the very broad term international relations? Do we not prosecute our friends for genocide? Is that the concept?
I think, Senator Shubridge, I think you're making a rhetorical point.
No, I'm trying to understand.
We just need to be aware of the position that the officials are in at the table in terms of their ability to.
I'm only after
opine.
a policy. I want to understand what international relations means. The department have said factors relevant to the consideration of whether or not to prosecute that are somehow uniquely determined by the attorney include, and I'll quote, international relations. In what way would international relations be determinative about prosecuting or not prosecuting a perpetrator for genocide?
I think the department's submission sets out that the legislation does not set specific criteria and has outlined considerations including international law considerations, including immunities, including national security considerations, including international relations in that context, and it's not, it wouldn't be appropriate for me to elaborate further.
No, that's not a fair reading of your submission. Your submission says, and I'll quote it, these factors may include considerations of international law, bracket, such as international relating to immunities, bracket, comma, ending there the considerations of international law, and then you say separately international relations as a separate factor. It's not a subset of international law. So in what way would consideration of international relations mean that Australia does not prosecute a perpetrator for genocide?
Senator, if I can add to Ms McKeague's answer, when we talk about offences under Division 268, of course, extended geographical jurisdiction applies to those. So it doesn't require that the offence is committed in Australia, and it doesn't require that the person who allegedly committed the offence has a nexus or a connection to Australia. Right. So when we talk about international relations, of course, not referring to individual matter or sort of speaking to one example where that might arise would be where there is a better forum in another country for that matter to be brought, or that bringing such a prosecution might prejudice investigation of another jurisdiction.
Well, no, you said as separate considerations in that same sentence, prosecutions that are being or might be brought in a foreign country. That's a separate consideration to international relations. You place international relations as a distinct and separate category, separate to that. So again, I go back and ask, in what instances would international relations, the attorney's consideration of international relations mean that the attorney decides not to hold a perpetrator of genocide to account?
Perhaps I can assist as well, Senator Shoebridge. Look, as a starting point, there was no suggestion that any of those considerations would necessarily be determinative. So while all those considerations might be raised, there's no suggestion at all that international relations would not be presented in a context outside our...
Sorry, Senator Shoebridge, just let the witness answer, and then we'll have to move on to your last point because we are over time. So
any information about international relations or international comity would also be presented in the context of advice from the department on our international law obligations. So I just wanted to make that clear as a starting point. The second point I'd make that, yes, although those items are listed separately, they're also interrelated in the sense that international law also, and the application of international law also has an international relations element. So looking at immunities, for example, as we've already heard evidence today, immunities are provided for under international law with a view to promoting diplomatic relations, enabling senior foreign officials from other governments to travel freely and to visit Australia. So that also, of course, be, in addition to the international law implications, that also evidently be a negative impact on Australia's relations with foreign countries if there was an attempt to prosecute a senior visiting dignitary who might be entitled to immunities as a matter of international law while they're in Australia. So yes, that's an international law consideration, but there are also international relations considerations that flow from that international law consequence.
It might negatively impact on our relations with a friend. Or an ally. It may negatively impact on our international relations with another country, and for that reason we wouldn't prosecute a perpetrator of genocide.
That's not my evidence, Senator Shoebridge.
Thank you.
Can I ask about
one last question, Senator Shoebridge, in relation to your second matter?
The other factor you say is relevant to whether or not Australia prosecutes a perpetrator for genocide is, and I'll quote, matters of public interest such as national security. Is it the department's position that matters of national security would... I'll start again. The submission says that matters of public interest such as national security would inform the discretion in such a way that only the attorney should exercise it. In what way would the public interest in relation to national security be determinative as or relevant in regard to holding a perpetrator for genocide to account? How would Australia's national security interests be relevant to whether or not Australia held a perpetrator of genocide to account?
I don't think it would be helpful even to speculate on the matters that might be relevant to the Attorney's consideration, Senator, in a particular case. All I can say that, as I've said previously, that advice would always be presented with the Department alongside advice as to the content of our international law obligations in a particular matter.
I'm not asking you to speculate.
Sorry.
I'm asking you to explain.
Sorry, Senator Shoebridge. I have to share the call.
I accept it's embarrassing.
Sorry, Senator Thorpe, you have the call. If you've got just a few questions to close
Can
out.
I just interrupt you? Thank you for chairing. I do need to log off now, which means we're past time.
Okay.
And the committee will lose quorum. If it's possible, if senators can put their questions and maybe they can be taken on notice to assist the committee.
Okay.
That's not
Otherwise,
fair.
I will miss this one. We are over time.
Okay.
Thank you.
All right.
I did this deliberately.
Senator Thorpe. Sorry, Senator Thorpe. We are at the end of the inquiry.
Shuts it down.
Can I get a motion from you, Senator Shoebridge, in relation to the time period for taking questions on notice, 27 August?
I'm happy to move that.
Thank you. That concludes today's proceedings. The committee has agreed that answers questions taken on notice at this hearing should be returned by close of business on Tuesday, 27 August 2024. I thank all witnesses who've given evidence to the committee today. Thanks also to Broadcasting and Secretariat. I declare the hearing adjourned. Thank you very much.